Hello, everyone, and welcome to Uncivil Law for a little Q&A. It's been a little bit since we did one of these, but we used to try to do it a little bit more often, but I've been really busy, and so we haven't had a chance. And every once in a while, I like to look to my comments and do a little bit of Q&A, a little bit of feedback, try to figure out where the channel is, try to figure out what's going on, what you're liking, what you're not liking, questions, comments, all that good stuff, and try to take your feedback for all the value it has, which, is often very positive, and I appreciate all the feedback I get. And so what we're going to do now is we're going to do some questions and answers and comments from previous videos. So here's the deal. If you're an uncivilian, you get to ask me a question in the chat right now. And if you ask me a question in the chat right now, I will answer your question. And if no one asks me questions, then I will go back to answering old comments. So if you want me to answer your questions, I will do that for the uncivilians. And for those of you who are watching, because this is a public video, but comments are only open for members, and you might be saying to yourself, I can't post a comment. How can I do that? Well, that's no problem. It's open for uncivilians. So for 99 cents a month, if you hit the join button, you can become an uncivilian. And then I will answer your questions. This is now an uncivilian feature. We're always looking for a way to give benefits to the people who support me, which seems only fair. You're giving me something, and I want to give you something back. So I figured a Q&A that was for you guys would be an appropriate way to go. So anyone can watch this video, but if you're not a member, you can't ask me a question. So become a member and you can ask me a question. Otherwise, we will go back to answering old YouTube comments, and that's fine. Either way is fine. And we'll just go back and answer some of this stuff. So Aaron asked me, what are the legal ramifications of saying Biden saying cops should shoot people in the leg? Sounds dangerous. Well, the standard rule there, Aaron, is the same rule it is for everyone. You can even advocate for illegal activity as long as it's not imminent. And that's true for everyone, regardless of whether you're a presidential nominee or otherwise. So anyone can encourage people to break the law. You can advocate for breaking the law. So even assuming that cops shooting people in the legs, and depending what he meant by that, it could be an illegal act, but it's just an opinion. You can advocate for illegal stuff. It's different than conspiracy. You can say it would be good for cops to shoot people in the leg, and it would be good for people to burn down businesses. It would be good for people to do whatever. And advocacy is allowed. It's different than conspiracy. What does want of jurisdiction mean? Well, want just means that you don't have something you need. That's a want. So the term want here just means you don't have something that you need. And the thing you don't have is jurisdiction. And jurisdiction can come in a couple different forms. It can be personal jurisdiction. You don't have jurisdiction over this person. It can be subject matter. You don't have jurisdiction over the subject matter. It can be based on mootness. The issue's old. It can be based on ripeness. The issue's not new enough. So, but to say there's want of jurisdiction is to say we can't hear this case because we don't have what we need. Is aiming directly for the legs as a policy legal? Well, let's answer that question this way. I would say that aiming directly at the legs is using deadly force. So I would say that the police can only aim directly at the legs to the extent that they can use deadly force, would be my answer to that. Because if you're shooting a gun, it's deadly force, not for the least of reasons that there's no guarantee if you're hitting the legs. And so if you are, I'll just go back to full video while there's still questions, and then we'll go back to the thing if I need it. But to the extent that you're using deadly force, which firing gun has to be deadly force, right? To the extent you're using deadly force, then you can only use that in response to the genuine need, which is going to be based on threat to the officer. You can't use deadly force merely to arrest. That there was a case on that from the Supreme Court. So you could shoot at the legs rather than shooting at the torso. But there's a reason the police shoot the torso. One is that it's the biggest target. And aiming with precision at the legs, I don't know if any of you use firearms. I use firearms. I do shooting. I'm not the greatest shot ever, but it's something I think is fun. And aiming with precision at the legs on the move, good luck with that. So there's a reason people aim at the torso. It's the biggest part of the body. And also has the benefit of shopping. $100 from Jason McConnell, who says, has to join just to send the super chat. Now to unjoin. Thanks for what you do. You know what, Jason? Thank you very, very much for your super chat of $100. I really, really appreciate it. I really genuinely do. And I don't want you to think that it doesn't go unnoticed. I don't want you to ever think that it's taken for granted. I don't take it for granted. And $100 is a huge amount. And so I endlessly thank you. I really, really appreciate it. Thank you. And I thank to all the people who are becoming members. That's really very generous of you. So thank you. So yeah, dang all y'all. What are your thoughts on King of the Hill? The TV show? I thought it was okay. Jamie B says, yes, I can chat. Yes, you can, because you're a member. How big a deal is if we see massive evidence of ballast harvesting? What would the Supreme Court do? Well, ballast harvesting may or may not be legal depending on your particular state and depending on exactly what you're talking about. From ballast harvesting to the way this term is typically used, it's allowed in California. I don't think it really should be. I don't really think it should be legal, but it is. So the Supreme Court is likely to rule anything is valid to the extent that it was valid under state law. So if you're talking about ballast harvesting in California seems to allow for that. And so it's very unlikely that the Supreme Court would overrule that. The most interesting issue, I wouldn't say the only, because I about to say that, I'll correct myself. The most interesting issue for the Supreme Court will probably be there is a federal law that defines what election day is. It defines election day. And the thing is, it defines an election day. An election day. So the biggest issue for the Supreme Court that I could potentially see is any ballot, particularly that's mailed after election day. So you could say for ballots that were postmarked by election day, that would make sense because they be, for those of you who know anything about contracts, this would be similar to the mailbox rule. This is really some old school contract stuff. But yeah, so in contract law, if you want to know when a contract is accepted, if it's mailed, the answer was when it's put in the mail. It's called the mailbox rule for exactly that reason. So anyways, you could say that putting a ballot in the mail is valid the day it's sent, because that would be the standard like contract law principle. So there's less a problem for ballots that are mailed before election day, but ballots that are, even if they're received after election day, because they were mailed on that day, so that makes sense. Ballots that are mailed after election day, though, that's a massive legal problem in face of federal law because it defines a particular election day. And so the biggest question I see for the Supreme Court would be ballots that were mailed after election day, which some states appear to allow for, and that doesn't seem to fly with the federal law. So that would be the biggest problem. And then the second biggest problem is trying to untangle that, because some states that would take ballots after they were mailed after election day may not segregate those ballots, right? They may not separate the ballots. They just put them into one big pile. So how do you undo that? What's the remedy? That's a whole problem. So that's the biggest legal problem I see for the Supreme Court potentially. Do you think there needs to be reform of 230? Yes, I've filmed a couple videos on reform of 230. I think the DOJ's proposal for reform of 230 makes a lot of sense. The DOJ's proposal for 230 essentially, in so many words, says that that websites can have any policy they like. They just have to publish the policy, and they have to be actually consistent with the policy. And they can't bury it in legalese. So they have to actually say what their policies is, and then they have to administrate responsive to that policy. So it's just an honesty in commerce provision, the way DOJ wrote it, and I think that survives constitutional test. You can have any policy you like, just be honest about it. So if you're Twitter and you want to say like nothing that supports the president is allowed, you can have that policy. Just actually be honest about it, and then administrate consistent with that principle, and everyone will know who you are, for better or worse. Just be honest. So I like the DOJ's proposal, and I do think I've already done a video on it. I think there are some weaknesses in the proposal. I've identified some potential constitutional problems. I've identified some potential statutory problems. So I'm not saying it's perfect. I'm not saying it's the end all be all, but I think it's a very good place to start. So I think that what Congress probably should do is take the DOJ's proposal and start working on it to try to figure out a way to to clarify the problems I saw and also clarify the problems I didn't see. Lemon Party says, no questions, just wanted to say good work. Thank you. 1990, Jason McCall becomes a supporter. Jimmy B becomes a supporter. Mazawrath becomes a supporter. Lemon Party became a supporter. Guinea became a supporter. OKC Vet HPA. RIP, my lovely wife, Michelle Grants. I am very, very sorry for you. I am very, very sorry for you, and I cannot even begin to understand the pain of that. I've never been married. I've had some long-term relationships, and so I can kind of a little bit try to approximate, but to try to actually extrapolate that to a marriage, I can't begin to really do that. And so all I can say is I'm sorry. And take care of yourself. Take care of yourself. And it's not, to the extent that you need to, I would recommend seeing a therapist. And there's no shame in that. I don't think there's any shame in seeking mental health any more than there is physical health. Talking to someone can really help. And I would just recommend that, but I'm very sorry for your loss. $5 or $25 from Mazeroth gives me $25 to say, let's discuss Bush versus Gore, since it must be relevant. I'll take that as a request to do a story on it, so I'll put it in my list of topics. So let me do that for paid stories. Make a note. Bush v. Gore. Bush v. Gore was a very interesting one in terms of split, but yeah. Thank you very much for the $25 super chat. Appreciate it. Okay, since there's no further questions in the chat, we'll go back to the comments from previous videos. I discovered yesterday I was shadow banned by Twitter. I can no longer tweet or comment anyone else. Numerous other Trump supporters are having the same issue and been complaining about it on Parler. Yeah, I can totally see that. I can totally see that Twitter is doing that. It seems very consistent with their behavior. In response to Twitter censors news to favor Biden, someone said, thank you. You are welcome. I always appreciate that. Where can we find your YouTube? Where can we find you when YouTube shuts down the channel or you did it now? Well, you can find me on Discord. There's a link in the description below. If you join my Discord, if I'm banned from YouTube, then I'll figure out where else I'm posting content and you can follow me there. Someone said, remember you're next on the list? Probably, yeah. By the way, the words Facebook standards, oxymoronic expression, are actually propaganda machine. Fair point. I appreciate that very much. Thank you. In response to my Twitter censors Biden, his office cannot have any bars, so whatever. The vertical kind, not the horizontal one. Fair. Legal Beagle says, I'm here. 10 million bots cannot be wrong. Okay, noted. Thank you, Legal Beagle, for commenting. It's nice to have you here. Someone said you might want to check Louis Rossman's video about how computer becomes abandoned and how merchant becomes a rightful possessor of said abandoned property. Well, I haven't seen his video, but if in my video that I did, I certainly commented about that, about abandonment law. I also talked about the standard rule in common law, and I talked about how it can be modified by contract and or state law. So yeah, Louis, to the extent that he was saying like it becomes the property of the person when it's abandoned, then yeah, but I'll check out his video. It'll be informative. Louis Rossman is an interesting guy. I'd be interested in talking to him. I'm particularly interested to know how his Secret Service case resolved, because I filmed some videos concerning Louis Rossman back earlier in my YouTube career, and Louis Rossman said that the Secret Service seized a whole bunch of Apple devices from him that were supposed to be imported. And I made a video being like, no, that's probably not really what happened, and you're not really seeing what's happening. But I understand that he filed suit against the Secret Service, so I'd be interested to know how that panned out. I'd be interested to know what really happened. So that'd be cool to talk to him and figure out what really happened. President Obama would have been the big guy, presumably. Yeah, but I left it open and vague because, the humor... The humor is left by making it unclear, right? So I say, well, I wonder who the big guy could be. I wonder who it could be. Like, I know that, but I'm making a point by the sarcasm, right? So, yeah. Thank you for becoming a member. Someone said, of all the QI cases you cover, which one of those was the most egregious you've read? Man, that's hard. Some of them are particularly bad. The cop shooting the dog in the head was particularly bad because there was no threat, right? So that case, there was a dog on a lead in the backyard. Okay, so there's a dog in a leash, right? And he's tied down to the ground or tied to a tree or whatever. So there's a dog on a lead in a backyard somewhere. And the story that we did, the cop comes up to the scene of the crime. There are already cops on scene. So he's not the first to arrive. He's a later arrival. And he comes to the scene with his cop car. And then, like, even though there are cops already on the scene and already, like, securing the thing, he walks into the backyard, even though there's no particular reason to go there. And there's a dog on a lead. And the dog is already at the end of its lead. It's already as far as it can go because the lead has a limit, like a leash, right? And so the dog is already at the end of its lead. And the story that we did is the cop walked up to the dog and then shot it in the head. That was pretty bad. Because what's the threat to the cop at that point? You know, the dog, he knew the dog was safe. There were already cops on the scene. The dog was on a lead. There was no threat. And then he walked up to the dog and then shot it in the head. That was pretty bad. How do you become a member? By hitting the join button. There should be a join button on your screen. For 99 cents a month, you too can become a member of the channel. So that was really, really bad. Yeah. Apple battery seized by customs. That's right. That was the case. I'll ask him. Yeah, I'd like to know how that finished up. I believe he wasn't able to get them. That's probably true, and I'd like to know why. Were they actually forgeries? Were they actually inauthentic? Because Lewis thought, well, they seized my lawful property. And he seemed to think of it because of a news story he was in. And I'm like, that doesn't seem likely. Customs doesn't really work that way. And I'm not blaming Lewis, and I said that in my videos. If you go back and watch what I said, I made it very clear I wasn't blaming Lewis. I'm like, maybe you did everything right, but that doesn't mean the products were legitimate. Maybe the products were illegitimate. No fault to you, but to say Customs screwed up, maybe they didn't screw up, right? Yeah. I know the details. Yeah, that's cool. I look forward to hearing them later, man. That's cool. Looks like you can't post a link to this video to Twitter either. That's hilarious. That's really nice to know that Twitter has banned me. Funny. Well, that might have been because Twitter was having a bit of a problem at the moment. That might not have been conspiracy. That might have been because Twitter was having a down problem. So, because Twitter was a little bit offline at the time I did the video. So, yeah. Aaron says they're manufactured by a plant in China who made original batteries. The supplier had an Apple logo and sticker for batteries versus generic logo. Custom seeded them as counterfeit. Yeah, that's right. That's a fact pattern. Yeah, that's right. That's right. That's what happened. And then the question is, are they counterfeit or are they authentic? Right? So I don't know if you might be still typing, but yeah, that's right. When the Kansas company framed the kid for murder because his mom rejected his advances and then claimed QI, that was the worst. There's been a lot of bad ones. Yeah. Imagine a U.S. where every terms of service, EULA, contract, lease, mortgage, build and remove your right to speech the same way they tell you not to smoke, drink, carry a weapon. Would you still defend private companies duct taping your mouth shut to enter? Yes. As a matter of fact, I would. Yes. Private, because we're doing law here, not policy. I'm not talking about like what I would like to be true. I'm talking about the law. And as a standard matter, private companies can discriminate against you willy-nilly. There are some exceptions to that, particularly when it comes to race, religion, creed, sex, that kind of thing, Title VII, Title IX, that kind of stuff. But under the law, they can discriminate against you on the basis of speech. That's perfectly fine. So would I be defending them? I'd be saying it's illegal. Yes. Sorry to disappoint you. Repair shop gave the laptop to the FBI, and much later, when he couldn't get no response, gave it the backup to another attorney, and then it got leaked. Yeah. Remove Twitter Section 230 protections. We need to reform 230. Someone says, I've defended Merriam-Webster before this and trusted it and used every day. Well, no more. If Merriam-Webster is going to pull this, they don't deserve to be called themselves trusted. Totally fair. The First Amendment restricts governments and institutions from censoring speech. True. The problem here is that we have what should be a regulated utility that has no government oversight. Quite possible. When the utility is closely tied to political players, and with Facebook and Twitter, execs work for Democrats, it's nothing more than skirting around the First Amendment by politicians to censor speech. That's a reasonable point, and that may be very why the law needs to change and adapt. Prima Facie says he's liking my content more and more. Well, thank you, Honest Face, for liking my content. I appreciate that. Brigadan231 says, I was about to accuse YouTube of burying it, but looking at the upload times, it'd be more than the fourth within 24 hours. Really? I'm uploading that much? So this is the fifth within 24 hours? Apparently I'm producing a lot of content. Who knew? I wasn't really trying to. 1999 from OKC Vet HPA says, thank you for all your kind words. I can't find the join button. Where is it located? This may be a limitation on the device you're using, because I think some devices don't make it apparent because of the way that those devices capture some of the revenue. But you can do it on a desktop for sure. And it would be next to the subscribe button. So if you don't see it on your device, that may be a limitation of your device. So some mobile devices may not make it available because they take revenue. So you can do it on desktop. You can do it on some mobile devices, but if you're not seeing it on your mobile device, it may be because you're being restricted. So the join button should be next to the subscribe button. If you don't see it, that will be why. But thank you very much. Yeah, on some mobile devices, you can't join. That's true. Twitter did crash. This has been normal for Merriam-Webster over the last 20 years, where they believe they are prescriptive instead of descriptive. Yeah. Do not use Merriam-Webster, assuming you still need the device. Fair point. Matthew says, I think you can still join on Android, not iOS, from what I've heard. Yeah, that might be a problem, because then they get 30% of the revenue, right? So yeah, that's an issue there. Watching Daily says, I think Barnes has it right for the 230 change. I disagree with Barnes. I disagree with Barnes' idea for the 230 change. I disagree with it sharply. And maybe it would be an interesting issue for me and Barnes to really talk about in depth. But I think Barnes has it wrong. What Barnes wants to do is force internet companies or publishers to abide by the First Amendment as though they were the government. So they wouldn't be able to restrict content under Barnes' proposal. They wouldn't be able to restrict content or edit content or delete content unless the government can. And in my opinion, that goes far too far as a matter of policy. Far too far. The problem there is the way the law is written, as it should be, is it applies to everyone equally. As it should, right? The law applies to everyone equally. Equal justice. So the law that whatever the way it's written applies to Facebook and Twitter, as well as mom and pop website, random church website, random religious website, and so forth and so on. So the idea that, these smaller sites should have to conform to the First Amendment, which would mean, for example, that if there's some church somewhere in some city, the First Baptist Church of whatever, and they have a comment section on their own website, they would be forced to abide by the First Amendment, which means that they would be forced, if they had a comment section, to allow people to comment according to the First Amendment in ways that would go directly against their own values. And that goes too far. It goes too far. We shouldn't force people to host content that goes directly against them or forego the right to have a comment section. That's too far. So I think Barnes has it wrong. The DOJ has a much better proposal, in my opinion. The DOJ simply says their proposal is, have any proposal you want, have any rule you want, just be consistent with it. Announce it honestly, apply it evenly, be consistent with it, be honest. Honesty in speech, honesty in commerce. That totally makes sense. And then Twitter would be forced to say, well, here are the rules, and actually apply them in a consistent and even fashion. And the DOJ's proposal is not perfect in terms of its contours. So there's flaws. I've already spotted it. I've already done a video on spotting the flaws. There are flaws. And so it's not perfect. There might be ways to do it better, But I think it's a good start. It's the right idea. So what I'd want to do if I were a member of Congress is take that and start working with it and see if I can make it better. See if I can improve the language. But I think it's the right idea. I think Barnes's idea goes way, way too far, in my opinion. To force every internet provider, big and small, you have to think about sites that don't want to be neutral. So Facebook and Twitter might want to pretend they're neutral, right? They might want to pretend they're neutral, but there's some websites that have no desire to even pretend they're neutral. That would go against what they believe, and forcing them to do content restriction that be consistent with the First Amendment goes way too far. Way too far. So, yeah. I think Barnes has it wrong. With all due respect to Barnes. Yeah. So, I think the DOJ has it right. And it passes. And although I spotted some potential constitutional problems, and I did, in its language, the fundamental idea is right. Because the fundamental idea is be honest in your commercial speech. And there, when you're talking about commercial speech, you're intermediate scrutiny, not strict scrutiny. So your intermediate scrutiny is a lower standard. So you can force commercial providers to be honest in their commercial speech. And so the provision is just be honest in your speech. Be honest about what your rules are. If you want to discriminate against Republicans and you want to discriminate against conservatives, go nuts. No problem. Just be honest in your rules. Our rules. Just be honest. And then apply them honestly and evenly. That's to be honest in your speech. So the DOJ's proposal is much better, in my opinion. How I see Viva's latest videos? I did. Nice Bowflex dumbbells. Thank you for noticing. Yeah, I do like the the dumbbells. They're nice. Yeah, so I think the DOJ's proposal is much better than Barnes. Welcome to all the people who are becoming supporters. I really, really appreciate it. Thank you. Felt like you're looking in my soul for the last 5 seconds. Luckily, I'm immune to gingers. Cute. Uncivil law. How would bots fill into the consistency idea? Well, it depends what we mean by bots, right? To the extent that bots are just simply applying standard rules, then I don't think bots are a problem. Like the bots I use on my channel, right, are just applying standard rules. They're a little bit blunt, but they're even, right? They apply this rule to everyone evenly. So they're even in their application. So bots that are just applying even rules to everybody in a sort of like, just here's the rule, here's the application, are fair. Artificial intelligence bots or smart bots become a little bit more problematic, which is more like what YouTube or Facebook or something like that is doing. So how you would deal with smart bots becomes a problem, and that's a potential issue where the law might need to be modified. The proposal is not perfect. How do you deal with smart bots? How do you deal with artificial intelligence bots under this proposal? And that's a fair point, right? So maybe we need to figure out how to deal with that, and the law doesn't really, and the proposal doesn't deal with that. So we need to figure that out. That's an area of weakness. We need to think about it more. Hello, Randon. How are you doing? Radian. Nice to have you there. Internet commentator said Lewis made an updated video, by the way. Cool. Let me click on that real fast. Oh, hold on. Let's see what he said. I'd be interested. What did he say? Can't load it for some reason. Copy link. I'm having trouble loading it, so I'll try it later then. Sorry. Lull to tease you, kind of blunt like you can be. I mean, I try to be honest in my speech. And if I'm blunt, it's because I think the answer is blunt. You mentioned the issue rule analysis. What's my conclusion? With respect to what, CDA 230 reform? I don't know yet. I don't know yet what the right answer is in 230 reform. I don't know yet. I've spotted the issue. I've spotted the problems. I've been analyzed the problem. I don't know what the answer is yet. And that's part of the process of writing legislation, or at least it should be, right? So we have an idea, and it's a good idea. And then the issue becomes, well, how do we make it better? So do I have the answer for how to fix it? I do not. I've spotted the issues so far. But then it becomes an issue of working on it and trying to make it better and consulting with people in legislative council and how do we fix the problems. So I don't know what the answer is yet. I just know here's some problems I found and can we go and work on it and fix it? I don't know yet. Right? And then if I were actually a member of Congress, what I'd be looking to do is I'd be looking to consult with people. I'd be looking to consult with special interest groups, looking to consult with lawyers, looking to consult with anyone who can say, hey, can you give me ideas on how to fix these problems? And they'd propose alternative language and maybe they'd fix my problem. I don't know the answer yet. I haven't gone that far. An AI messing up would still be in good faith. It depends how the new rule is written, right? So that might be a problem, depending on how the new rule is written. It's a fair issue. Cut to 50 minutes or so. Another comment earlier in the video was talking about, okay, to be clear, I like your opinions. I appreciate the clearness of your opinions. Thank you. I try to be clear. I try not to hide the ball. If I'm unclear or uncertain, I express doubt. And I expressed doubt quite a lot on this channel. There's a lot of things where I don't know, like I just did just now, where I'm like, I don't know the answer yet. I don't know. Right? If I have doubt, I express doubt. If I'm clear, I'm clear. I just try to be honest and fair. Any updates on the Flynn case? No, not yet. And nor will they be in any time in the near future. Don't worry about it. There's no way that's happening anytime in the near future. Flynn moved for dismissal or recusal, and he's going to move for some other stuff. And this case is not going anywhere in the near future. So no worries. What's going on with qualified immunity? Nothing right now at the moment. Sorry I mentioned your bots, to be blunt, and sorry my comment wasn't clear on the teasing. That's fine. Yeah, the bots I have should comply with the proposal from DOJ because they are clear and they are even and they're blunt and they're very fixed rules. So no problem, but I appreciate the teasing. I took it genuinely. Just got hello. I super appreciate your intelligence and honesty. Yeah, be honest in your speech. I try to be honest in my speech. I try to be as fair as I can be. If I feel like something's clear, I present a clear opinion. If I feel like it's unclear, I present doubt. If I agree with something, I agree with it. If I disagree with it, I disagree with it. I've disagreed with courts. Right? I've disagreed with courts. I disagreed relatively recently with a unanimous Court of Appeals opinion. I'm like, well, 3 judges disagree with me. I mean, in the Ford case, right? Ford versus Montana, which we covered on my channel recently. Apparently, I'm disagreeing with 42 states. 42 states disagree with me. 42 states apparently think that I'm wrong. Okay. I mean, that's what it is. 42 states think I'm wrong. Okay. I made a note of it and I said, yeah, I think you're wrong. Here's what I think the better analysis is. Could I be wrong? Sure. Of course I could be wrong. We'll find out, right? I mean, there was an 8-1 Supreme Court opinion. Kansas v. Glover, right? And I disagreed with the 8 and agreed with the 1, which was Sotomayor, which you wouldn't necessarily expect from a conservative legal thinker. Why would you expect the conservative to agree with an 8-1 opinion when the 1 is from Sotomayor? Probably not, but I thought Sotomayor had the better end of it. So I disagreed with 8 members of the Supreme Court. If I think you're wrong, I'm wrong. If I think, I'll just express an opinion. That's fine. How I thought about ever submitting an amicus brief in any particular case? Not in particular. Writing an amicus takes a lot of time and a lot of energy. And if you're getting paid for it, a lot of money. The people that writes amicus gets paid, baby. So do you have $30,000? We'll talk. Matthew Logo says, especially when I say something I express out. That's true. No wine tonight? No. What are scenarios where strict scrutiny is triggered? And then Ryden says it's pronounced Ryden. Yeah. Okay. So your standard hierarchy for constitutional law analysis, or for that matter, any sort of analysis. So you have 3 categories: rational basis, intermediate scrutiny, strict scrutiny. So rational basis, you just need a reason, any reason, and any legitimate motive and execution. It's pretty easy. Things do fail rational basis from time to time. It's a little bit unusual, but it does happen. But you would expect it to pass because it's so open. And rational basis is most things government does, because most things do not trigger specific rights. So intermediate scrutiny, then you look to a substantial governmental interest. and it has to be narrowly tailored to that interest. And typically for intermediate scrutiny, you're looking for discrimination on the basis of sex, time, place, manner restriction on the First Amendment. Second Amendment, at least it's the case law that exists right now on Second Amendment law, would be for anything that's not a core right. Unfortunately, the courts of appeal think quite a lot of things are not core rights. So that's a problem. And then strict scrutiny is any essential part of a right. So most First Amendment analysis is there. Discrimination on the basis of race is strict scrutiny. Discrimination on the basis of religion, strict scrutiny. That kind of stuff is strict scrutiny. When you're discriminating on a suspect class or a constitutional or on a core constitutional guarantee, then you're under strict scrutiny under the current case law. Washington Daily says 42 states disagree with the last half of your viewers on the video. That's fair. Internet commentator says, I'm busy tonight, so I won't be looking through the questions and seeing if you missed any, and the lower volume should be fine. Yeah, it's fine. I'm doing fine. I live in a ride-in. Very cute. One thing I've noticed about conservative-leaning law students, we don't feel personally attacked if other students don't agree with their conservative position. Yeah, that seems to also be a thing, at least at the moment, with conservative pundits as well. Because Ben Shapiro has said, and I tend to think he's telling the truth, that he's willing to have conversation with left-leaning people. And left-leaning people are unwilling to have conversations with him. So it seems these days, the conservatives are more tolerant in general to opposing positions from the left. And the left are less tolerant to positions from the right. Another way that this has been phrased is that right-leaning people think that left-leaning people are mistaken or not sufficiently informed or have made a mistake in their reasoning somewhere. And left-leaning people think that right-leaning people are evil. So right-leaning people are more willing to talk because it's like, you've made a mistake somewhere, and let me figure out where the mistake is. The left-leaning people will be like, no, you're just the devil. So I don't know the degree to which that's really true, but that's sort of a sentiment that seems to be expressed. And also just taking a sort of ultimate ironic perspective. If you think about what classic liberalism is, the right is more classically liberal these days. How did that happen? How did the right become more classically liberal? How did the conservatives become more classically liberal? Something is wrong, man. Yeah, how do we become more classically liberal where we're like, well, freedom of speech is good for everybody, and freedom of expression is good, and we like individual rights, and how that happened? This is some very weird times, Matthew points out there might have a fourth level of analysis. Jacobson, yes, Jacobson might be a different level. That's fair. Yeah, all right, so let's return to comments since there are no further questions from the chat. See how this works? If you give me a chat comment, I will answer it. If not, I go back to the standard thing. All right. Volro says, calling sexual preference offensive is offensive to bisexuals. Yeah, that's really interesting. We had a whole discussion on my Discord about that yesterday, about when does it become offensive? Because I said, because trying to line draw is one of the things I try to do, right? When I'm thinking about this. If I said in my chat, interestingly, yesterday, I said, what's the difference between these two statements? I'm gay and I prefer men. I'm bi and I prefer men. And I didn't really get a satisfactory answer to that question about what's the difference between those two statements. And then because it implies it's a choice but a pure preference in the other one, and it wouldn't make sense to say, well, I'm gay and I prefer men. That doesn't make sense as a statement because it's a 100% allocation. So then I asked the next logical question in the sequence. It's like, okay, if I'm gay and I prefer men doesn't make sense because a gay person would by definition only want men, so the statement doesn't make sense. Would I'm bi but I 99% prefer men, would that make coherent sense? And so what is the difference? And it's a line drawing problem. What's the difference between the language? And we never really got to a satisfactory answer, in my opinion, on that one, trying to figure the answer to that. It kind of evolved. But I'm still a little bit unclear on why you can say, well, I'm gay and I prefer men versus I'm bi and I prefer men. And one is okay and one is not. I mean, it's literally the same sentence. I've just replaced gay with bi. And why is one okay and one not? And it's because the gay is 100%. and a bi person is not. Well, what if the bi person is 99? They're still bi. I mean, definitionally, right? So so the 99% preferred man can say he prefers without it being a problem, but the 100% can't because it implies choice. I don't understand this. It was very, very weird. So we couldn't quite square that circle in my head. All bi people are gay, not all gays are bi. The way that I understand the terminology, that is not correct. At least the way I understand it. Bi and gay are mutually exclusive. The way I understand it. But maybe that's wrong. But the way I understand bi and gay are mutually exclusive. You can't be both bi and gay at the same time. That's what I understand. And if I'm wrong, then we'll have a discussion about that. Yeah. Response to Merriam-Webster earlier this year, they redefined racism. They did, and they did find it in a circular way, which was hilarious. I'd love to know the reasoning behind this law, but it sounds dumb. Well, that's a little bit frustrating. From Gnarl Mooncat, that's a bit frustrating, Gnarl. I'd love to know the reasoning behind the law, but it just sounds dumb. I mean, I kind of, the whole point of the video is trying to explain the reasoning. So I don't know if I failed or whatever, but it's a little bit of irritating, man. It's like, I don't know. So if you understand correctly, because you look at the effects and not the motive, right? That's the standard under the law right now. That means that facially not content neutral regulation could be considered and treated as content neutral if it was content neutral because the effect of the content neutral justification. So if it wasn't facially content neutral, but in its application it was content neutral, it's hard to imagine how it would be true, but I suppose that would logically flow. I know Scott has acknowledged the ostensibly neutral laws can be not neutral if there's maltreatment. To what degree does motive matter? Well, in the law as it is right now, motive doesn't matter. If it's content based in its reality, then motive doesn't matter. So, like, if you could show a law that was content based on its face, but content neutral strictly in its application, which I'm not sure how that's possible, but if you could, then you might be under a different analysis. If it's somehow content neutral, in fact, that might be true. But I can't imagine how that'd be possible. Justice Thomas is basically telegraphing. We're not looking at this case, but if you brought another case, we'd look at that one. Basically, that's correct. Yes, he's telegraphing where he wants to be. And there's a whole bunch of comments. 2250 regarding Zarin versus OLL. Okay, I'm looking at the fact patterns provided by Wikipedia. I'm interested to know how he gets to knows it's illegal. Basically, an anonymous poster keeps on putting messages glorifying some bombings that contain the plaintiff's phone number. Each time plaintiff would notify AOL will take down the postings, but the new ones would be reposted. Given anonymity, I'm assuming it's either sock pockets or you could post messages without logging. I don't ever use AOL. It seems cut and dry under 230. AOL will quite plausibly receive too many messages to have someone vet each one, so they reasonably have no idea the message was until it brought to their attention. Maybe there's more than 2-paragraph summary, but I'm not seeing it. Based on a 2-paragraph summary, that seems correct. You wouldn't really be able to get to knowing because every time they dealt it, they addressed it, right? So, yeah, that seems correct. With respect to categorical immunity, I think he's saying they didn't say categorical immunity, so they didn't mean categorical immunity. They didn't say categorical immunity in the very next section. They did say categorical immunity in the very next section. So obviously they meant something other than categorical immunity. I don't disagree with what he's saying. I just think I disagree with his readings of the facts of AOL. I could totally accept the Congress meant in C1, you can't treat an ISP by a publisher just because they remove something. So if a distributor would be liable under the old rule, they'd still be liable under 230. Okay. Fair. I didn't quite get that from Justice Thomas's view, and I didn't quite get that from the way the statute is written, but maybe that's what he's trying to allude to. I didn't quite get that if that's what he was going for, but maybe that's right. If the platform does the standard naive solution of replacing affixed links to strings with asterisks, then that would be, in my opinion, a specific example of editing that would be covered by 2A. Yeah. If an employee comes along and adds I'm a poopy head, Not so much. Yeah, it depends. What do we mean by editing? Yeah, exactly right. And replacing things by asterisks is a thing that I might do, for example. So for exactly this reason. So yes. In response to Dirty World, okay, I think Justice Thomas may be on firmer ground. This case is pretty on point for what he's suggesting. Defendant puts up a website specifically for anonymously submitting dirt on people. Okay. Defendant adds a comment after each anonymous post. Okay. The Sixth Circuit dismissed because of CDA 230. That seems problematic under the case law. I think, layman's read, the appeal court tried to distinguish based on two factors. The specific content added by defendant wasn't the defaming content, although in fairness, it seems pretty defamatory. She just named non-parties in the suit. So what they added wasn't defamatory. Okay, that makes sense as a split. And plaintiff made no attempt to subpoena defendant for information on who authored the posts, which is more of a procedural problem. So then maybe that's a factor there. I think Justice Thomas could have a point if he's arguing because defendant added non-infringing comment, he's thus aware of the infringing content and thus should have been liable if they're treated distributors. I'm not sure Justice Thomas would actually make the argument. Yeah, under the way of 230 as it's actually drafted, actual notice of defamatory content doesn't get you there. The way it's drafted right now. So if he was saying that by commenting on it, they have actual notice, that doesn't matter. The way it's drafted. If you're adding non-defamatory content, then that edit seems fine. So yeah, then I think if you think Justice Thomas was on point for what he was suggesting, based on at least your summary of the case, then it seems correct. If they weren't adding things that were defamatory, then they're not responsible under CDA. And if they fail to subpoena requests for who made the information, then that's a procedural defect in the lawsuit. So that would seem to be the correct result, at least based on the summary. I was just checking to see if anyone asked me a question in chat, in case you're wondering why I was looking, because I want to make sure to prioritize the people in chat who ask questions. With respect to Amazon product liability, wasn't it the case where Amazon was deemed liable because you only send messages to the actual seller through Amazon? For example, if all Amazon was doing was hosting a listing and you communicate directly through the seller, they wouldn't have been liable. I'd have to double check the facts of that case. I don't think that's correct. I think there was more than the fact that they were a pass-through. I don't think that's right, but I'd have to double check. I vaguely remember hearing something like that in Lawful Masses, but it was a fair while ago, so maybe not. I don't think that's quite right. I think the issue there was whether or not they became a seller of the goods. And that would go to what AOL was specifically doing and the degree to which they were a consignor or not, among other things. With respect to human trafficking, also worth noting that there's a specific provision carving this out in E5. I'm guessing that's amendment? Yes. Either way, the point seems it is. Yeah, it's an amendment. CDA 230. E3 suggests it doesn't apply to state law either, so it presumably means all criminal law is fair game. To the extent it's not getting consistent, yes. With respect to product liability, it sounds to me like Justice Thomas is saying these cases have nothing to do with publishing content, but CDA 230 got applied anyway, assuming he's not mischaracterizing it. He maybe has a point. Maybe I'm steel-manning his argument. Yeah, I felt like Justice Thomas was saying some things that weren't well developed, and maybe it's because he's so smart that he just assumes everyone knows these things. But to the extent that's what's going on, I'm not as smart as him, and so he didn't explain some things where it felt a little bit thin. So maybe he was right in some things, but it felt underdeveloped, and it feels like you steel-manned his arguments. So you have improved upon his arguments in some respects. So good for you, but that I didn't quite get some of the stuff from what he wrote. Guinea says, if I'm choosing something because I want to, am I not doing what I prefer? That's a very fair point. And also, to some extent, it's not clear that any preference anyone has for anything is really a choice. Is preference really a choice in any context? Like if generally speaking, I like both Mexican and Chinese food, and you ask me which one I want right now, and I say I prefer one right now, is that strictly speaking a choice? I mean, I'm describing something I want. versus something I don't at that moment. But is that really a choice that I made? I'm simply describing a reality that's currently existing. So, and like if you have a choice that's a little bit more hard set, like for example, milk chocolate versus dark chocolate would be a reasonable example for me. For me, I don't like dark chocolate. I like milk chocolate. And so if you ask me which I prefer, for me, milk chocolate is a very strong preference. There might be a situation where I eat dark chocolate because, but I very strongly prefer milk chocolate. Or to bring it to a food example, Indian food, not a huge fan. So if you ask me like, would I prefer Chinese or Mexican or Italian versus Indian, the odds are very strongly yes. So is that strictly speaking a choice that I made that time? Even if one time I would say other things, or if I never would went to an Indian restaurant, is that a choice? So it's not really clear that preferences are really ever a choice. If you really prefer one thing versus another thing, can it be said that you prefer it because of choice? So like is preference ever a choice? And your preference in any given moment might change, right? So like if I like Chinese and Mexican and Italian relatively evenly, which I do, right? So I like Chinese, Mexican, and Italian food relatively evenly, all things considered. But in any given moment, if I say I prefer one versus another, is it really a choice in that moment? Did I choose that? I don't know, man. I'm not sure preferences are really a choice, even if they're flexible and variable. So I don't know. So it's a bit weird. Orangey Health says Tin Simp. Apparently it looked orangey in that video, so yeah. Ah, Bray Ooh. I could see my wife's twitching as she was listening. Good stuff as always. I have to apologize because I don't normally mispronounce names. So, it's really unusual for me to mispronounce names, and so I'm sorry. Okay. Always watching Loving You, Uncivil. Did some research into who owns the MW dictionary. Interesting stuff. Explains how they're able to change it so fast. Yeah. Biden crimes don't look so bad. What's a little slavery among friends? Yeah, it's a fair point. I don't see what the problem is. What's the problem? Okay, this is Jay Emery in response to my video. 10 Australian dollars from Dante, not available. Sorry I wrote a huge comment. Topic was interesting. No problem. I'm happy to do. That's what this purpose of these things are, right? Response to comments, and you gave me some intelligent comments, right? And so I wanted to respond because it was intelligent. It was thoughtful. And so I'll respond to it in depth because it's thoughtful. And you're like, here's some ideas. And I'm like, those ideas are interesting. I'm not really sure they were sufficiently developed by Thomas. But, there's some ideas here that might be what he's going for. So, I spent time on it because it was worthy of spending time on. So thank you for the comment, really. Thank you. In response to MLAB Buffalo, I don't see what the problem is. What's the problem? Is the problem the cartels just want to help baseball athletes that had a dream because they love the sport so much and dream to playing Major League Baseball? It might be that they want to extract, lifetime indebtedness from them. The cartels saw hope and dreams in their eyes and wanted to help them and support them accomplish their dreams. Who's the victim in this situation? Well, I'd respectfully suggest that the baseball people themselves are the victims because now they're owned by the cartel and they have to give them a 35% commission to the cartel. Matthew says, uncivil law. You just made the argument. The reason it's found offensive is because it's used dismissively by some people who say you only sexually prefer men and you can change it if you want to. I'm not 100% sure that's responsive to what I was saying. I'm not really sure that preferences are strictly changeable ever, because I'm not really sure you choose your preferences in any context, even if they're changeable. So if I say if you ask me on any given day if I prefer Mexican, Chinese, or Italian, and at that particular moment I desire Chinese, does that mean that I can change that preference at that moment? Now I can act against the preference, right? So if we ultimately select Italian rather than Chinese, I can act against the preference. But can I actually change my preference in that moment? And it's not clear I can. So it's not clear you can ever change the preference, really. You can act against the preference, and the preference may not be very strong, so like it doesn't bother you a huge amount, right, to do one over the other. So this preference isn't really a strong preference, but you can act against the preference. But is it clear that you choose your preferences? So I don't know. It seems a little bit problematic. I'll be in Austin this weekend. Any way I can give you a bottle of home brew mead? Yes, you can. Join my Discord. It's in the description, and tag me, and we'll see what we can set up. I love to meet people. It's nature versus nurture. No, I don't know if that's quite right, because I don't know how your preferences came to be is the operative issue. So whether or not your preferences came from nature versus nurture, I don't think is quite right. Because whatever the reason for your preference existing is your preference now, one way or another. So whether it came from nurture or nature is a bit irrelevant. But it's still your preference at that moment. So Guinea says, I'll be here in Austin every weekend. Oh, wait, I'm here every weekend. Great. Let's meet up. Join my Discord. Tag me. Maybe we can hook up. That'll be fine. This is the very means by which disenfranchised, pesky, complaining, constitution-loving Americans will be replacing our numbers dwindling due to pandemic and economic collapse. That's really, really true. Omen CM says, how about you get to keep your 230 protection as long as you follow the First Amendment? Yeah, we discussed that. I think Barnes has it wrong. I think he goes way, way too far. In other news, Guinea says, I'll make sure you say my name right. Is it not Guinea? If I mispronounced your name, I'm sorry. I thought that was the natural pronunciation, but I apologize. The hat really ties the room together. Fair enough. Reel me this, MW. Biological preferences defined as, so based upon their theory, male and female are biological. Very, very cute. Very nice. In response to Stephen, for me, the general concept of details of this lawsuit are not new. I think these practices of getting Cuban players to America was an open secret. Yes. I had heard this stuff reported before. Yes, I think we all have. It was a bit of an open secret, but to actually see it exposed in court filings and described, Ginny, Well, I like gin. Gin is one of my favorite two alcohols. Gin and bourbon are my favorites. Depends whether or not I like it. It's for me, the difference between gin and bourbon is the difference between white and red wine. And I know it's not a perfect analogy, but that's how kind of like I think about it. So yeah, I like gin when I want something a little bit more bright and sprightly, and I like bourbon when I want something a little bit more robust and a little bit more pensive. But I like gin. Gin is definitely one of my favorite two mixers. So Ginny, fair enough, very good. Yeah, we should discuss what our favorite gins are. That'd be good. Now I know it's basic. I know it's a little bit typical, but my favorite gin is probably Beefeater. It's some bars use it as their rail, but I like Beefeater. I think it's a very solid choice. Other gins I really like Tanqueray 10. I really like that, and I like the original Bombay, not the Sapphire. I think Bombay Sapphire leaves a little bit to be desired, but the original Bombay is really good. So original Bombay, Tanqueray 10, and Beefeater are my favorite gins. So that's what I like. Grand Marnier, I love Grand Marnier. Sometimes when I'm ordering shots at a bar, a very, very common, if I'm ordering shots for a bunch of people, one of the things I'll go to is Grand Marnier. It's fantastic. It's an orange liqueur. What's not to love? Everyone loves Grand Marnier. Yeah, do that as a shooter in a bar. Fantastic. Yeah. She shouldn't have apologized to her. Never apologize to these people. It makes you look you weak. Yeah, I don't really agree with that in the case of Justice Barrett. It was a fair apology and a prudent one. I think the general principle is probably right, but in the specific application, I'd probably disagree. Alpha says he prefers not to drink. Alpha is sad. Curtis says, I like how you attorneys think. First asking if something is relevant and then proceeding for the implications. Yeah, right? If it's not relevant, it doesn't matter. So, like, what is relevant, what is not relevant? Andrew said, best gin I ever had was Colbar Blue Bottle with hand-glued label on it. So much juniper is making off the Christmas tree. That's funny. Very, very cute and very, very fair. Sounds promising. Justin says, are you upset that MW made an update, which they do as terms are invented or changed, or that you got to see it in real time? My upset is that they didn't follow procedure. One of the things that tends to make me conservative, at least as far as I'm concerned, one of the things that makes me conservative is I prefer process to outcome. I tend to lean a lot more on process than outcome. So I think a lot more about how things should be done than what is done. And so I look to the process. And if I don't like a particular outcome, my thought process is in terms of modifying the process and trying to universalize it, because processes can't be perfect, right? So if I come up with an outcome that is incorrect, then maybe the process needs to be modified. But if I'm going to do that, I need to modify it in such a way that I can universalize it to everything and it will work. So I tend to think a lot more about the process than outcome is one of the things that makes me conservative, at least to me. And so one of the things that upset me about Merriam-Webster was the violation of process. Like, even if this is the proper outcome, the fact the process was violated in such a blatant and one-sided way is more than a little upsetting to me. And so that was the nature of my upset to me. Although it'd be interesting to probe into where the senator got her talking points and when MW planned to do this update. Basically, trace back on both sides where it's originated and see if the same person people behind it. Either way, there are a lot of words that weren't offensive until they were. At some point, there's a minute of change as to the update. Yeah, that's kind of my point. Yeah, that's really not promising. This is utterly unbelievable. Dictionaries are always regarded as foundational. Yes, and should be unbiased and nonpartisan. I agree. It's disgusting to say the least that they're flimsy changing terms. This is bad as someone coming along changing standardized length of a foot or an inch. That's a very fair point. Glenn says he appreciates my work. I appreciate that very much. Thank you very much. In response, Merriam-Webster redefines a word. Everything is a choice except dying. There's some validity to that. Someone can always make a choice contra to their preferences, right? All actions you perform with your will is a choice. Fair. Out of control is someone not choosing their actions. Please explain how gaiety does not fall under its general rule of life. People have no promise of gripping. I mean, yeah, I mean, you can always make choices contra to your preferences, no matter how strong they are. I mean, we do have free will. So, I mean, there's a fair point there somewhere. I wrote of Merriam-Webster when they unironically acted bling bling. I don't object to that because, I mean, it is a well-used phrase and does have a definition, so it's a little bit fine. Yeah. With response to CNN, hell is frozen over. That was very funny. And CNN asked tough questions of Democrats. Hell is frozen over. That's a funny comment. Cop-splaining needs to be added. That's funny. Yeah, it's cute. Senator XO in chat says, I once ordered Grand Marnier once. The bartender asked, what? Grandma J? Not super promising. That's super not promising. Yeah. That's a bit problem. If transgender can transition one way, then regretfully reverse transition later, then it is a choice and preference. Well, I'll agree with you half. I mean, the decision to transition or not is a choice, because someone could choose not to do that. So that's a choice. The degree to which is a preference, I don't know. But yeah. Alpha says, I'm the only straight-edge law student that I know of. Of course, having a 5-year-old child helps, regardless of my disinterest. That's very, very cute. And good luck with that, Adam. Alpha, I hope the law school thing works out for you. And I hope you're learning something of value from this channel in your law school studies. I hope it's interesting. Presumably it's interesting enough for you to be here. I appreciate that. I really do. I appreciate that. Thank you. I asked my gay and lesbian friends if it was offensive to them and said, hell no, that's crazy, to change it. And it'll probably backfire, setting a bad standard towards other words when political narrative needs help. Fair point. In response to Justice Thomas opines from Street Racer, so by your logic, the preamble has legal effect since it's part of the Constitution. Now that's been decided for a while. Okay, so the legal effect of the preamble of the Constitution is an interesting point. So the courts have generally ruled, with respect to the preamble of the Constitution, that you can't look to it separately for substantive effect, right? Because it's a policy statement. So you can't look to it for substantive effect. You can't look to the preamble for I have a right because of what the preamble says. So you can't do that. But I don't think the courts have said, and someone may correct me, that you can't look to the preamble of the Constitution as a way to help clarify a provision that might otherwise be vague. Because to the extent you need to interpret vague language in the Constitution, looking at the preamble as an idea of where they're trying to go, I think would be proper. So you can't resort to the preamble as a substantive right unto itself. But to the extent that there's a vagueness in a substantive provision, then you could look to the preamble to help clarify what they were trying to aim for. And that would be proper. And that would be the same analysis in 230, right? You can't look to sections A and B for substantive effect unto themselves, but you could look to it to the extent that there's a word that was unclear and say, well, this was what they were trying to accomplish. So if there are multiple different interpretations, let's pick the one that's most consistent with the policy that was stated. So I think you could do that for the Constitution too. I'm not aware of anything that said to the contrary. So if you had a range of different potential interpretations of a substantive provision, and one was more consistent with the preamble than not, so if you had it in the abstract of multiple different provisions and one was more consistent with the preamble, then it would be consistent to interpret consistent with the preamble. But you can't look to it as independent authority. So yes, I'm saying the same thing for the Constitution as I would be saying for the preamble of the Constitution. If there's clarity in the substance, then you can't go to the preamble to undo that. The preamble can't undo the substance. But to the extent there's vagueness, the preamble can be informative. So I think it's fair. Alpha Adam got restricted by Streamlabs. I'm sorry, I don't know why. This is one of the problems with the bots, because they seem to delete multiple different messages, and I don't know why they do it. I don't know what the setting is where they delete multiple messages. I'm sorry, Adam. I don't know how they decide what chats to delete and what not, but they delete like a whole bunch. I don't even know what the problem is, and I'm sorry. I don't know. But I'll just read what you said. You're only straight edge law student, and then you said absolutely it is, and then you said to Matthew, haha, nice. Many of our fellow classmates are legitimate alcoholics. That is a well-known problem in the legal profession. Then you said, nailed it. This channel fits a lot of gaps for my piss poor con class. That's cute. It also keeps me on my toes with Crim and Crim Pro. Very good. Yeah. Very fair. Very, very fair. I'm glad it's helpful to you. Someone said, I have no reason to believe Merriam-Webster is trying to appear woke. Okay, if that's your conclusion, fair enough. I presented all the facts, and if you think that the conclusion is unfair, that they're trying to appear woke, fantastic. I presented all the facts, so you can reach a different conclusion. I still disagree with you, but, my sexual preference is to have sexual preferences. That's cute. Regarding the difference between C1 and C2 and 230, Justice Thomas is making the point that if Congress wanted to eliminate liability for internet computer services held by another provider, they could have used the phrase shall be held liable instead of the phrase shall be treated as a publisher or speaker, which is effectively the same in this context. I mean, they're different words, but shall be treated as, because if the publisher has liability or the speaker has liability, which they do, then to say shall be treated as the publisher or speaker is to say they shall be liable because of the chain of reasoning. So I don't think there's a difference in fact once you apply it. What Justice Thomas is saying, C1 does not preclude distributor liability, mere publisher speaker liability, which is true. And then the question is, who is the publisher speaker? And when it says, well, these people shall be treated as the publisher speaker, shall not be treated as publisher speaker, then that's a problem. Yeah. And probably because they said a bad word, they'll see if this is deleted. And it was deleted. So there you go. I wonder if I can change that in Streamlabs so it doesn't delete the tweets and just... let me see if I can delete that and change that in Streamlabs. Give me 1 second. So that like replaces content rather than deletes it. That'd be nice. 1 moment, please. Talk amongst yourselves. Let's see. It doesn't seem to be. Auto permit, no. Default blacklist, no. Yeah, so this is the settings that you can see in Streamlabs. So it's like, yeah. So this is, so we have the default blacklist in Streamlabs. So yeah, just the default blacklist, which I don't even know what that is. So I have it set to not deliver the punishment message, because why? And just auto permit none. And there's no setting here to like change that. So I have no way to change that apparently, which is really frustrating. And I'm sorry, because I want to keep my chat relatively civil, and there's no way for me to delete it. And I'm sorry about that. But yeah, that's what we're going on. I know I'm streaming my Streamlabs on screen. That's fine. No problem. You saw what's up. It's fine. Let's see, where were we? I wonder if the judge has a defamation case against her for this. That's funny. No, unfortunately not. Probably. Remember when Obama added Neil Armstrong wiki gazing up the moon the day that Armstrong died? We're never going to stop this communist revolution until we have an idea of how we got there. Okay. In response to Merriam-Webster, red pilled A, maybe Fahrenheit 451 would be a better analogy with matter and book burning going on. Maybe. But I think 1984 is pretty good. Orientation comes from the word orient. I'm not sure if that's true or not. I have to look into etymology. 420 atheism says, aren't we supposed to keep things uncivil? As a matter of fact, no. And the term uncivil law is just a play on words of civil law. It's cute. But I do like civility. I like people being nice to each other, because it devolves too much if people are unnice to each other. A little bit of civility goes a long way. So, no. In response to Merriam-Webster said he watched Sargon. In response to the Merriam-Webster video, I watched Sargon's take on it. I'm not sure I can swear to it, but I don't think I saw Sargon's take on Amy Coney Barrett before I did that video. I don't watch Sargon. I don't watch everything Sargon does. I only see him intermittently. I don't remember watching his content before I did that. So it's possible I watched it, and as a result, I saw something that he did and borrowed it. But I don't think I did. So maybe we just thought along similar lines rather than me getting it from him. So yeah. Orient just means east. The opposite is occidental. Okay. Noted. Winston would be proud. Very cute. Barrett Light 50. Yeah. Why am I surprised what the left has been doing since Karl Marx? I don't know, man. Maybe I'm just surprised all the time. Yeah. In response to Merriam-Webster, God help us, yes. I'm sorry, I don't know your name, even though I subscribe to your channel. My name is Kurt, but uncivil law is fine. I want to say something about this video. Usually outrage does not play well. This video is an exception. I see a man who loves language, a perfect love for lawyer. I see a man with a crystal clear version of truth. At most, a necessary quality for a lawyer. I see a man with tremendous intellect. You're awesome. Thank you. I appreciate that. I see a great man, so sad, but also gracious. So you resort to sarcasm as a way to express rage. Yeah. This video shows who you are at the moment of truth. I respect you already or would have subscribed. Now I really like you. You're principled. I cannot express myself the way you do, but I'm hurt the way you are by the attack on culture. Here's to you. If our great civilization survives, the sickening barrage of the lunatic left and their globalist backers, you'll be one of the pillars that saved it. May God bless you. May God bless the United States of America. And to hell with our enemies, foreign and domestic. Well, that may be the nicest compliment anyone's ever given me in the history of time. That's a lot of compliment. So I'll just say thank you for your very kind words. That's a lot. Yeah. So, I try to, one of the things I try to do is think. And, God or nature or whatever has provided me with a mind. And so I try to read and I try to think and try to actually think through things and try to be honest and fair and try to express areas where I know things and where I don't and just try to think. And, I really, really appreciate your kind comments because that's a lot. And, I just try to be honest about who I am and try to be honest about my perspective, try to be honest about where I'm coming from, try to be open about everything and just try to be the best I can be. And so that's very humbling and I really appreciate it. Thank you. That's very kind of you. It's Kurt with a K, by the way, for those of you who are trying to spell it. It's Kurt with a K. Yeah. K-Dog, yeah. Yeah. For those of you who don't know, and I wouldn't expect you to, because why would you unless you looked it up? Because of course I did, right? So Kurt with a K and Kurt with a C come from different etymologies. They're different derivations. So Kurt with a C comes from Curtis, which comes from Greek. But Kurt with a K comes from Conrad. It's German. And Kurt with a K from Conrad means wise counselor. I hope to live up to it. So there you go. There's a little bit of etymology lesson on names for you for the day. Yeah. Another YouTuber point out PlayStation 8.0 updates records of your voice in party chat. That's my understanding. Retains it so others can report you to moderated bard. That's my understanding. They're obtaining voice records. That's scary. And it's pondered, what if they have a record saying preference a few months ago and now real-time update the dictionary? That's very true. Retaining both public and private chats potentially allows them to cancel anyone they don't like. I definitely like to hear these details from Sony. That's a very, very fair point. Very, very good. Yes. Yeah, that's a very fair point. Okay, in response to Justice Thomas factors out 230, quoting me, this is what I said. I can factor out all the trouble of looking at what the words meant when they were written, only considering what the words mean now. I may have misspoken there. I may have misspoken if that's a direct quote, because that doesn't sound like what I was trying to say or what I did say. And if I did say that, that's wrong. No. So if I did say that, that was an incorrect statement. So what I was trying to say, and maybe I said it incorrectly, what you should be doing in originalist interpretation or textualist interpretation, apologize, because this is about textualism. What you should be doing in textualist interpretation is absolutely looking at what the words meant when they were written, not what they mean now. So you do look to what the words mean when they were written. That's true. What the textualist does, what Gorsuch does, what I think is better, is you don't look to the intent. You don't look to the purpose. You look merely to the words. So what Gorsuch does, and what his approach that I like at this point, is he just looks to the words on the page. He doesn't ask what Congress is trying to do. He doesn't ask what Congress's purpose is. He doesn't asking what they're hoping for, what their dreams is. He's just asking, what are the words on the page? And that is and absolutely should be and must be informed by what they meant at the time. So as you're reading things back in time, you absolutely have to figure out what those words meant, because the language may have drifted. So if I said that I was factoring out what the words meant when they were written, then I shouldn't have said that. That was not right. And that was a misspeak. No, you should look at what the words mean when they were written, not now. What you should do, according to Gorsuch, and what I think is better, is you should factor out the intent and purpose and just look to the words. The words are better. The words are objective and clear. And so I at this point, favor the textualist approach of Gorsuch. So if I said this was a misspeak. And then he says, quoting me, and this is how I perceive leftists in the courts, from interpreting what the law means to what they mean instead of what it says. Yeah, so what I said, I think, and what I was trying to say is, this is how I perceive the difference between textualism and originalism. So this is the split, in my mind, between Gorsuch on the one hand and Scalia on the other hand. Thomas is actually a poorer example of this. No, someone like Scalia or Alito. So what's the difference between Thomas and someone like Scalia or Alito? What Scalia or Alito will do, it seems to me, is they'll look to the text as the primary guide, but then they'll also, as a secondary guide, look to purpose and intent behind the words. So they won't just stop at the words. They'll also look to the purpose and intent and the hopes behind it. That's more of an originalist approach. That's more Scalia and Alito approach. What Gorsuch is doing is he's not looking to that secondary stuff, in my view. He's looking merely to the pure words and what they mean. So he doesn't factor in the intent and purpose. He just looks to the words. And that's why that gays in the workplace case came out differently between Gorsuch on the one hand and Alito on the other hand. That was a textualist originalist split. And that was the case that really showed me the difference and said, oh, no, I really am more on Gorsuch's side. I'm more on textualist, right? So when you look to that gays in the workplace case, right, the way the statute was written, right, it says in employment, right, in an employment context, this is Title VII of the Civil Rights Act of 1964. In an employment context, you cannot discriminate in employment on the basis of sex. That was the operative language. In an employment context, you cannot discriminate on the basis of sex. All right? And then Gorsuch and Alito come out differently on that, right? So then if you look at Alito's opinion in that case, what he said is, well, Congress, when they were considering this provision, Title VII, they considered the possibility of putting gay in the statute. They considered the possibility of putting it in the text. It was considered as an option. And they decided not to do it. It was too controversial at the time. They couldn't get the votes, right? So they didn't put discrimination on the basis of sexual preference in the statute or sexual orientation in the statute. They didn't put that in there. And so what Alito says, in his opinion, in so many words, is it would be very weird to read sex, right, as including something that Congress expressly rejected. They considered this possibility. They considered this language, and they rejected it. So it'd be very odd to interpret sex, according to Alito, to include something that they expressly rejected. So you can't understand sex to include something they expressly rejected. That's Alito's approach, right? He's looking beyond the text that was there to intent and purpose. Well, they didn't intend this. And the reason he knows they didn't intend this is they considered this and rejected it. So they couldn't possibly have intended it, right? They considered it and rejected it. They couldn't have possibly intended it. So he's looking beyond the text on the page and looking to the purpose and intent. And he says, well, given the intent and purpose, given the fact they expressly rejected it, it can't possibly have been their purpose. So it'd be absurd to interpret sex as including it. That's Alito's opinion, right? But then Gorsuch comes along. And Gorsuch has the better opinion, in my opinion. Gorsuch has the better opinion. What Gorsuch said is, look, what the provision says is you can't discriminate on the basis of sex, right? That's what it says. You can't discriminate on the basis of sex in the context of employment. That's the clear language on the page. Well, what does sex mean? Well, I mean, it means the same thing now it meant in 1965. It means male or female. You can't discriminate on the basis of someone being male or female. It has the exact same meaning now it did in 1965. Notwithstanding what the left wants, right? Sex means exactly the same thing to an ordinary, normal person now that might 1965. The language hasn't changed. So you can't discriminate on the basis of sex. You can't discriminate on the basis someone is female, where you wouldn't do it to a male. And you can't discriminate on the basis of a male if you wouldn't do it to a female. You have to be even. And then you consider, what does it mean to be gay? Right? What does it mean to be gay? And he says, look, 2 employees get married to a woman. 2 employees get married to a woman. Right? 2 employees get married to a woman. One is male, one is female. And if you're not firing both, if you're only firing the one that married the same sex partner, you discriminate on the basis of sex. They both did the exact same thing. But you only fired one. And you did it because they were one sex, not the other sex. If they had been the other sex, you wouldn't have fired them. So you discriminate on the basis of sex. And I'm like, yeah, that's right. It's 100% right. Yeah, it's 100% right. You can't discriminate on the basis of gay without discriminating on the basis of sex. Right, 100% correct. You can't do it. You can't do it. You fired one and not the other because they were the sex they were, not the other sex, and you can't do that. And therefore, to discriminate on the basis of sex, to discriminate on the basis of gay is inherently to discriminate on the basis of sex. You can't do it. And I'm like, yeah, you're right. You can't do it. And so I'm like, oh, Gorsuch is right. He's right. You can't do it. So even though they didn't write gay into the statute, even though they didn't maybe want it, when you actually go follow the logic all the way through and just go to the words on the page, that's the right result. It has to be. And that was like the difference between originalism and textualism, right? That was the difference between Alito and Gorsuch. And that's where I'm like, oh, it turns out I'm a textualist now. I'm a textualist, not an originalist. I don't care what you want. I don't care what your intent is. That's Alito. I thought I was an originalist all this time. No, I'm not an originalist. I'm a textualist, man. Gorsuch is the new hotness. So that's, exactly the split here between textualism and originalism. And the reason I said that originalism runs into a problem is because the difference between, in my view, between originalism and more left-leaning thinking is just you flip the order. So that's the problem when you go down this road. The problem with originalism, there's the problem with originalism, is when you go down this road, you open yourself up. Because now all you have to do is flip the order, right? So an originalist would say, let's look to the text primarily and then look to intent and purpose. But what a more left-leaning member of the court would probably say is, let's look first to intent and purpose and then look to the text, right? Let's look at what they're trying to do. The text is secondary. Don't worry about what was written. Just look at what they were trying to do. And let's further that objective, whatever it is. Congress can't write laws. They suck at laws. Just let's try to figure out what they're trying to do. And, the words are just in the way. That's left-leaning legal thinking. The words are in the way. We can figure out what they were trying to do, and let's further that objective by manifesting their intent, regardless of the words. So that's left-leaning legal thinking. Intent and purpose supersedes the words. Conservatives say the text supersedes the intent and purpose, right? So they're just flipping the order. And the reason I like textualism is I don't even run into that problem. Because I just completely discount purpose and intent. It's not relevant to me. I don't care. All I care about is what are the words on the page. What do you actually write? What are the words on the page? What did you actually write? And those words should and must be interpreted what they meant at the time. Absolutely, 100%. Words change. They meant what they meant when they were written. But then just follow the logic all the way through. And whatever happens, happens. So that was what I was trying to say. Perhaps poorly. Yeah. That's what I was trying to say. Perhaps poorly. And there was a whole bunch of comments in chat, so I'll respond to this. Respond to a whole bunch of stuff because there's a whole bunch of stuff in chat. So someone said you're like the anti-legal legal. Probably. Yes, I probably am the anti-legal legal. That's very true. Yeah. If someone wants me for Ninth Circuit Court of Appeals, Viva's the anti-legal legal. That's probably true too. Someone said I'm far more grounded in reality and law than legal. Yeah, legal is more of a, well, no disrespect, because I like Viva quite a lot. But Viva's more, and I think it's actually good. He's more of a pop presenter. I think he's solid. He's just more pop. But yeah, I try to be a little bit more depth. Yeah. What's the substantive difference between a lawyer, attorney, counselor, or litigator? Are they just used interchangeably? In the United States, they are. Other countries make a distinction between these terms. But in the United States, they're used interchangeably. I mean, the only difference there is litigator, because litigator litigates, which is to say, like, goes to court and actually litigates. So that's the only, like, term that's specialized. But other between lawyer, attorney, and counselor, those terms are used interchangeably in the United States. Some countries make a distinction. For example, the United Kingdom makes a distinction. Barristers go to court, and solicitors do paper law. But in the United States, we don't make that distinction. Someone asked, is ACB more textualist or originalist? Well, based on her own testimony, she is an originalist. Also, the way ACB was asked about this question, and ACB apparently does not split this the way I do. She by her testimony, says textualism is an approach for a statute. So she splits these terms. She uses them differently than me, which is fine. Maybe she uses different terms to describe my same concepts. But ACB said textualism is how you do a text of a statute. So she doesn't think of textualism as an approach in constitutional law. She thinks of it as an approach in text and statute. You know, so that's where she splits it. That's not how I split it. So, at least by her testimony, she seems to be more an originalist than a textualist. She's more likely to agree with Scalia, based on whatever I can tell. Justice White seems to view things in terms of historical context. Yeah, that's fair. Like, different justices have different weights of things, right? So that's perfectly proper. Matt says, don't forget, intent only matters in administrative law. You can drag out the attorney of Congress and tell him to pound, but you got to pull in from an agency and its gospel. That can be very, very true, where it's committed to an agency. Very true. A lawyer can tactically spend all day in a cube writing contracts and never set foot in a courtroom, but a litigator cannot. That's true. Yeah, that's exactly right. A lawyer, if you say someone's a lawyer, it doesn't indicate if they go to court or not. But litigator tends to imply very strongly that they go to court, so that's a problem. The entirety of Congress doesn't matter, but some rando from an agency is God. Yeah, that's Chevron Brand X Hour. We've commented about that quite a lot on this channel. Yes. Internet commentator says the really big thing was that interpreting because of turned on to be a but-for logical test as a approximate cause. Yeah, that's true too. And I thought he had the better end of that. Yeah, but because of turned into a but-for as opposed to proximate cause. Yeah, so whether it was a factor, which is what Gorsuch said, any factor, a factor, versus whether it was essentially the dominant factor. Yeah, but because of, I mean, you can interpret it either way, but I thought Gorsuch has the better end of it as a but-for cause. Yeah, I'm doing it because of this, and also a whole bunch of other reasons, but I'm still doing it because of this. So even if it wasn't my most dominant reason, I'm still doing it because of that, right? It was a reason. So I thought Gorsuch had it better. Gorsuch would be the worst PC player character at the D&D table? Maybe. allowing agencies to unilaterally interpret their own stuff is a nightmare. Yep, we've commented about that a lot on this channel. Brandex, Our, Chevron, we've commented about it a lot. Wickard, we have some thoughts. So question, this might be an answer. Based on that interpretation, if you fire people who say they're gay, and that's fine because you're firing both men and women if they say they're gay. No, that's a problem because you're only firing them. No, that doesn't work. But it's a fair question, Dante, right? It's not okay if you fire both men and women if they're gay, because it's still discrimination on the basis of sex. Even if you're firing both men and women if they're gay, it's still discriminating on the basis of sex. Why? Because if the man was a woman and the woman was a man, you wouldn't be firing them, right? They're only gay because of the sex they are. If the man is gay, right? If the man is gay, if he were a woman, he wouldn't be gay, right? So you're firing the man because he's not a woman, and vice versa. You're firing the woman because she's not a man. So it's still discrimination on the basis of sex, even though you're treating both men and women the same, equally. Because if they were the other sex, they wouldn't be gay and you wouldn't be firing them. So it's still discrimination on the basis of sex. So even though you fire both men and women, it doesn't work. Because if they were the other sex, they wouldn't be gay and you wouldn't be firing them. So it's discrimination on the basis of sex. No, but yeah. Someone said he ain't that hot. Fair enough. Internet commentator said, previously in some circumstances, the boss could say I fired you for a permissible reason, and a permissible reason say the impermissible reason, but not after this. Yeah, which is totally fair. Totally fair. Yeah. If one of the reasons is an improper reason, you're hosed, no matter what your proper reasons are. Right. Which makes total sense, because if you think about it in its application, for a second, its application, the scenario would be you have both a gay employee and a straight employee, and you're not going to fire them right away. But you have a whole bunch of policies, like time card or, registering in work or whatever. You have a whole bunch of policies. And so you hold the policies more strictly against the gay employee than you would against the non-gay employee. So even though they both do the same bad stuff, you fire the gay employee faster. So even though you have legitimate reasons, you held them more strictly against the gay employee because they're gay. So that's discrimination on the basis of sex. You wouldn't have done it if they were gay. You would have kept them employed. And the reason I know that is because you kept the one who wasn't gay employed, even though they did the same things. So even though you had legitimate reasons to fire both, you didn't fire both. You only fired one. And that's discrimination on the basis of sex. And you can't do that. So I thought, yeah, that made total sense. Music Hole says, I just joined to ask this question. Thank you for joining. The impermissible reason poisons the well. It does, yeah. If you have the impermissible reason, it doesn't fly. And but for cause means as long as the impermissible reason contributes, it's illegal. Absolutely. 100% correct. And that seems to be the best interpretation of the statute. I did because of that. If I did because of that, is the fact you're gay immaterial to the equation or not? Right? If I fire you for cause and you just happen to be gay, no problem. Right? I can fire you if you're gay or a woman or black or over 40 or any other protected category. I can fire you for cause, no problem. But am I firing you for cause? Am I treating you the same as if you weren't those things? If the answer is no, I'm treating you worse because you're one of those things, that's unequal protection of law. Can't do it. So yeah, if 1% of the reason I fired you, is because you're gay, then 1% of the reason I fired you is because of sex. And that's an improper motivation. Can't do that. Can't do it. Yeah. I didn't ask a question because I want to know what your thoughts on California Prop 25. I think I'll be challenged. What's California Prop 25? I'm not that familiar with the stuff. Is that the one to try to repeal the the protections of the protections of discrimination. California can repeal its own law. I don't see how you could challenge that off the top of my head unless there's some way they violated state law, which I don't think they did. So if they wind up repealing their own state law protections, then they're idiots, but it's legal as far as I can tell. That being the case, though, the federal protections would still apply, notwithstanding what California does. So California can take away its own state protections, but federal protections would still apply. California is still an idiot, though. Follow up to ACB Textualist Originalist. Why have a split method of interpreting statutes versus the Constitution? Is the Constitution kind of a super statute? Well, I agree with the second half. Constitution is a super statute, to be sure. I agree with the second half. That Constitution is a super statute. It's at least in my mind, and the reason I disagree with how ACB creates this split, because I don't think of textualism the way she does. One of the reasons is I think that the Constitution is just a statute. It's a superior statute, though. So it's not just a statute, right? It's a superior statute. It's a statute with priority. It has priority. But I wouldn't differentiate in interpretation between a statute and a constitution. I interpret them the same way. So I don't split my interpretation between a constitution and a text. I interpret them the same way. And if there's a conflict, the constitution wins because this is superior status. But to the first half of your question, why you have a split of interpretation philosophy? Because you have to. You have to have a philosophy of interpreting statutes or in constitution or anything else for that matter. You have to have a baseline rule of how you're going to do this in the abstract. Because, the only alternative to having a baseline set of rules that you're going to apply before you ever see a case. So before you ever see a case, here's the baseline rules I'm going to apply. The only alternative to that is to say, well, I'm just going to base it on whatever this particular case is. And the problem there is you're not guaranteed any consistency from case to case because it will be based on whatever you feel at any given moment, right? Because you don't have it anchored to anything. So if you don't have a baseline underlying set of rules and you just go with, what I judge on this particular case, you don't have any consistency. And that's a problem because then you're arbitrary, right? You're making all kinds of decisions that are not consistent with each other based on whatever is guiding you in that particular moment, based on a whim, essentially. It doesn't work. So you have to have a set of rules in advance before you ever see the case on how you're going to interpret cases. And there's a couple different approaches for this, and there's different canons of rules that have been developed on how you do this. So without ever looking at a case, it's like, well, here are the set of rules I'm going to apply. And then you come to me with your case, and now I'm going to look at it and then apply it fairly, but then it's fair because everyone gets the same treatment. But there isn't just one rule. There's not one possible rule. There's a couple different rules, and I've named some of them, right? You can look to just text. You can look to text intent. You can look to intent and then text. You can look to consequentialism as another approach for a thing. You look to the consequences and what will emerge, and then kind of utilitarian approach is another way to go about it. Utilitarian. So you try to maximize the benefit and minimize the suffering in a utilitarian kind of way is another approach you can do. But you have to have some baseline rules. And I've considered a whole bunch of options, and I think textualism is the way to go. But you could come up with a different opinion and then apply that evenly. But you have to have a set of rules. What if you fire everyone if you have one gay employee? I don't know. I haven't thought about that. That seems unhelpful, though. To fire everyone because you have one gay employee seems a bit unhelpful. I don't know. I haven't really thought about that particular hypothetical, but okay. What steps are you taking to prepare yourself for your inevitable rise to stardom as an internet icon of law teaching superstar? My soul is well prepared. Thank you. I'm trying to become more popular. I'm trying to figure out how to do it better and how to be even better and how to gain more subscribers. I have 16,000 subs, which is great. But, if I could have 1.6 million subs, that'd be even better. So, for every one of you guys, can you contact 99 friends? That'd be great. This is where This is where blurring genders with sex hurts the left, yes. Okay, how about this? An employer fires a trans woman who's married to a cis woman, but the employee fires the employee as a man. I don't know. I don't know. Why are you asking me really, really complicated questions, man? It sounds really complicated. You've altered variables, so I have to do math in my head. I don't know. Thanks. Great. The state of all these determines unless federal law supersedes. Yes, that's fair. Right. What if I fire everyone because my employees gays? I don't know. California Proposition 25, replacing cash bail with an algorithm. Depends on the algorithm. But maybe. Possible. It depends on the algorithm. Could work. First of its kind in the country. If it's the first of its kind, then we're in new legal ground, right? But depending on what the algorithm is, might work. Depends on the algorithm, I guess. You have to get into the details. Prop 25 is being written by the left and challenged by a bunch of leftists. That's funny. Historical. Yeah. Replace cash bail with assessing risk. Depending on the algorithm, might be okay. You have to get into the details to figure out if it would pass constitutional muster. Might work. I asked to join this, says Andrew Rohn. Thank you. Number one, really enjoyed your content insight. Back to being fired by gay. Would Burrell versus Hobby Lobby have any play in the hypothetical? Burrell versus Hobby Lobby basically says that in the context of closely owned stores, that you can't prevent them from having religious preferences. Would that extend to other Title VII issues? Maybe. Yeah, maybe. Maybe Burrell extends to other things beyond religion. Possibly. Yeah, possibly. So if you're Hobby Lobby and you wanted to try to bring that issue, maybe. Yeah, possible. Am I aware with any Gorsuch opinion that I disagree with? Not off the top of my head, but probably. Well, I can think of at least one. He didn't write the opinion, but I can think of at least one that I disagree with him, which would be Kansas v. Glover. He was in the majority with the 8. I disagreed with him. I thought Sotomayor was right. So he didn't author that opinion, but he joined the majority, and I disagreed with the majority. I agreed with Sotomayor, even though Sotomayor, at this point, because Ginsburg died, Sotomayor is the most left person on the court, probably, by most metrics. So even though Sotomayor is the most left person on the court, and Gorsuch is my right-wing fanboy, I still disagreed with Gorsuch and agreed with Sotomayor. What can you say? It happens. There you go. Bail's a bit of a mess. Courts seem to be routinely express bail. Yeah. Dang, my question got joined to ask, got skipped. Oh, it did? I'm sorry, Musical. Let me see if I can find your question. I apologize. Let me see if I can find your question. I don't want to do that. I don't want to skip your question. Let me scroll back up and see if I can find it. Musical said, could it be possible for the Supreme Court to protect itself from court packing by arguing to upset the balance of power since there was their intent? Musical, you have raised a very good question. And I don't know how that plays out. That's really tough. But the idea that you're trying to go to, and I think it's the right idea, is that when Congress is doing this by packing the court the way they're doing it, it is somehow interfering with a plenary power of the judicial branch. And I don't know how you do that legally. That's a tough one, because Congress has changed the seating of the court over time, right? I think the Supreme Court, when it first existed, was 5. I could double check my math or check my history, but I think it was 5. And then at one point it was 10 and reduced to 9. So it's been different numbers over different times. So you have a bit of a hard time saying that Congress can't change the number. But is that the same thing as changing the number from 9 to 19 and then packing the court? And can the court do anything about it because it's upsetting the sovereignty of their branch? Whew, man, that's a hell of a fight. I don't know how you deal with that legally. I don't know if you have to pull something out of your ass to justify that. I don't know how you deal with that as originalist or textualist. Well, as originalist is slightly easier because you can go like the original intent and purpose of Article 3. So an originalist might be able to squeeze that out of Article 3. A textualist is going to have a damn hard time doing that out of the text. But can the Supreme Court do something about it if Congress decides to pack the court? Well, that's going to be a bitch to figure out. And then the question is, how does the Supreme Court get the case? And some people have been talking about taking away the court's appellate jurisdiction, which is a thing you can do. You can take away the court's appellate jurisdiction in particular cases. So one of the things they said was, well, what if we have a statute that changes the number of the court and we take away the court's appellate jurisdiction? Okay, we can do that, but then the court will try to squeeze it into original jurisdiction because the Congress can't take that away because it deals with ministers. Is one of the things that the Supreme Court has original jurisdiction on. So they'll say, well, this deals with ministers and therefore we have original jurisdiction. And then they have to figure out who can bring the case, right? So if you're trying to change the Supreme Court, then who has standing? That's the next problem. Who has standing? And presumably only members of the court have standing because they're the only ones being impacted by it. So then basically the court has to bring the thing sua sponte in original jurisdiction. So essentially they're the one filing a lawsuit with themselves. That's super fun. And then they have to go from there. And then there's a recusal problem because they're all impacted by that decision. And also to the extent that in the interim, Congress has actually made appointments. Who actually gets to hear the case? Because if Congress has made appointments and they've been sworn in, who actually gets to hear it? Yeah, but I've definitely forecasted this problem musical. There is a potential mechanism here for the court to try to deal with this, but trying to figure out how to sell that is a bit of a problem. The Supreme Court would like to sua sponte on its own motion, with the standing being the members of the court themselves, would like to create a lawsuit out of nowhere in its original jurisdiction in the Supreme Court, and then hear the case that directly impacts them on the legality and constitutionality of court packing. That's a tough road to hoe, man. There are some problems. I'm not saying it's impossible, but I think for this reason, among many others, that if they start doing court packing, we're talking about true constitutional crisis. I think court packing is a true constitutional crisis. I think it is completely different to anything else that has ever happened in the history of ever. Well, I don't know quite that far, but because U.S. history has a lot of stuff. But court packing is a massive, massive constitutional problem. It is a threat to the structure of separation of powers. It is a threat to the separation of judicial versus legal theories. It is a threat to federalism. It is... I'm hard-pressed to think of anything that scares me as much as court packing. I think it is a massive threat to the solvency of the republic. And I don't say that out of a desire to be hyperbolic or out of a desire to oversell it. I say that because I genuinely think that's true. I think that court packing is an existential threat to the solvency of the republic. I think it poses massive problems. And all the problems I just highlighted with the court trying to hear this is just part of the tip of the iceberg. It's a constitutional existential crisis. It's a constitutional crisis. And if they do it, I don't know how we come back from that. I mean, court packing was a bad idea in 1930s when Roosevelt thought of it in the first place and proposed it. It was a horrible idea for all the things. And a lot of people have talked about things the various parties have done. They got rid of the blue slips. First of all, I don't care. I think the blue slips were dumb. I never liked blue slips. Blue slips, by the way, for those of you who don't know, was where the senator from the state could block a nominee. So one senator could block the nominee if they're from the same state, which doesn't make any sense. Why should one senator have this veto-like power? It's total crap. And apparently, Matthew was telling me earlier that Republicans were the ones that invented it in the first place, in like 1917 or 1918. The Republicans invented it. But be that as it may, I think it's stupid. So the Republicans got rid of it. I don't like blue slips. I don't care who's in power. I apply my principles consistently. Democrat, Republican, I don't care who's in power. Blue slips are stupid. One senator should not have the power to block a nominee. That's just dumb. Doesn't make any sense. The entire Senate was elected. Let them vote. Another thing I don't care about is getting rid of the filibuster. I don't like the filibuster. I've thought that for years. I don't care. Get rid of the filibuster. And that's a Democratic or Republican rule. I apply that evenly. I don't like the filibuster. Haven't liked the filibuster for years. I'd vote for it. I'd get rid of it right now. I don't care. Don't like the filibuster. You know, some of the stuff that was done in terms of the Senate procedure when the Democrats took away the filibuster for lower court nominees, when the Republicans took away the filibuster for the Supreme Court, right? And then the games they played with Garland, which I feel are legitimate, because the Senate is essentially saying they don't want to appoint a nominee they don't agree with, and that's their prerogative. There's a whole checks and balances. Like Scalia was appointed with 97 votes. Ginsburg was appointed with like 96 votes, right? So these far left, far right people were appointed basically unanimously. Those days are over. So if the Senate wants to do like Ginsburg, Scalia, we'll appoint them essentially unanimously. That's cool. If they want to say we don't want to appoint anyone that disagrees with our preference about what a judge should be, I think that's cool too. So I don't have any problem with the Republicans not holding hearings for someone. I don't have any problems with them holding hearings for someone. I don't have any problems with the Democrats do it either. That's their prerogative. If they get control, that's their prerogative. It's fine. It's even application. Even application is totally cool. So I'm totally cool with all that. But I think packing the court is an existential crisis to the Constitution. I think it is completely unlike any of the things I just named. I don't see how you can do that and maintain the balance of powers that we have between the branches of government. I don't see how you can do that and maintain the separation between politics and law. I don't see how you can do that and not just turn the court into a true political institution, which to the extent it's not, and I hope it's not, you'd just be abandoning that premise completely. I don't see how you do that and turn the judicial branch into essentially a super legislature and maintain federalism with a separation between states and federal government. I think court packing is the singular most dangerous thing I can think of doing to the solvency of the republic. It is that big a deal. And it is a constitutional crisis. And I don't see how you come back from that. And I hope I'm wrong. I really do. And I don't know if the Supreme Court can do something about it or not, for all the reasons I talked about earlier, because of all the problems that are there. But I think trying to pack the court is by far and away the biggest threat to the solvency of the Constitution that I can contemplate. It is a step that is apocalyptic in its magnitude. It is truly terrifying in every possible sense. And if the Democrats do it, I don't know where we go from there. I don't know how we come back from that. It's that big a deal. So I don't know if the Supreme Court can do something about it or not, Music Hall, but it is. If the Democrats wind up trying to pack the court, and I pray to God they don't, because I don't know where you go from there. I think it's that big a deal. Sorry to be all downer on you, but I just call it like I see it, and I cannot think of anything that is more dangerous to do than packing the court. It's a huge, unbelievable deal with repercussions that I don't think people are even beginning to fully appreciate. I think it's that big a deal. So, thank you for the question, Musical. Hope you enjoyed that answer that I went back to find. I hope you got your question worth out of that one. Feel satisfied? Okay. It's just horrible. No, it is all the horrible. Yeah. Uncivil will replace Roberts as Chief Justice? Maybe. I don't have 99 friends. Fair enough. You could use RBG's method of determining how many minorities and or females that statute ultimate ruling impacts. Fair enough. I'd argue dissolving the Supreme Court is worse. Well, yeah, I mean, that would be worse. I agree with you, Matt, that dissolving the Supreme Court would be worse because I'd be getting completely rid of one branch of the three branches of government. So, yes, you're right. Dissolving the Supreme Court would, in fact, be worse as a constitutional threat. Yes, you're correct. But, so you're like, I can't think of anything worse. And you're like, here's a thing that's worse. I probably shouldn't have said, I can't think of anything that's worse. Because one of the principles that I believe in very strongly is there's no bottom to hell. It's one of the principles I firmly believe in at my core. So I really shouldn't have said it can't be worse. Because one of the things I believe in my heart is it can always be worse. It can always be worse. Always. There is no bottom to hell. It can always be worse. No matter how bad it is, it can always be worse. It's turtles all the way down, baby. Yeah, so I shouldn't have said it can't be worse. I suppose what I really was trying to say is there's nothing on the table that's being proposed at this moment that is worse. But Matthew's correct. Dissolving the Supreme Court is worse, and that's not even the bottom. There are things that are more bottom than that. There is always more bottom. There is no bottom to hell. It is always the worst. There is always more worse. Yeah, so fair enough, Matthew. Fair enough. Could a Republican congressman bring suit against arguing it messes with structure of federal government and they're affected? No, probably not. This has been tried before, and you can't do it as an individual member of Congress. You could probably do it if Congress voted on it collectively, but seeing as they're packing the court, they're not going to do that. So an individual member of Congress, no, probably not. They can handle it through the shadow docket. Yeah. Filibuster all goes away back to the Roman Republic. Okay. The filibuster goes all the way back to the Roman Republic. I still think it's stupid. I disagree with the Romans. What do you want? The last thing we need is faster government. I just disagree. I mean, the House of Representatives used to have a filibuster in like the 19th century, and they got rid of it. And I don't think you need a filibuster. I think, if 51 people have enough votes, they should be allowed to exercise control. I don't think that means you should get rid of debate, but I think the filibuster is bad. It prevents a duly elected majority from having their will. So just a fundamental disagreement. Could it cause a civil war? Hell yes. What are my feelings on the 22nd Amendment? I have to Google what the 22nd Amendment is because it's been a while. What's the 22nd Amendment? No person shall be elected president more than twice. I think it's fine. No problem. This is why Kamala Harris probably will get Joe Biden to resign on January the 21st, 2023, so she can be president for 10 years. But yeah, I think it's fine. No problem with that. I think packing the court might lead to a civil war. I think it would. I think the probability is very high. Because I think that packing the court upsets federalism, and then it's hard to see how that doesn't lead to a civil war. When the Supreme Court of the United States has just started dictating from on high, it's hard to see how states continue to go along with that. I think the threat of a civil war is very high for court packing. I don't disagree. It's one of the worst ideas. That said, I think it's a policy question, not something that can be dealt with the court. Hedinger, I've sort of at some length highlighted the problems there. I think to some detail. It's a problem. It's a problem trying to squeeze this in. Can you get it outside being a policy question? I don't know, man. That's a tough road to hoe. I think I kind of illustrated that one, yeah. Have I braved the lines to vote yet? Not yet. Next week. The end result of legitimizing Scottish packing would be you essentially dissolve the court every time the Senate changes the majority. Probably. So I'd argue that Scottish packing is basically as bad as dissolving the court. It's close. It's pretty bad. I'm not sure which is actually worse. It's pretty bad. Yeah. Have I ever heard of disparate impact judicial theory? Of course. Disparate impact is well-known theory. The idea is that if something has a disparate impact, it's a way to prove discrimination. And disparate impact is used as a way to show discrimination as a methodology. If something has a disparate impact, it's a way to show the discrimination has occurred. So yes, I'm well familiar with it as a legal theory. As a political talking point, I'm also familiar with it, that the idea that anything that has a disparate impact means there was racism, which is going too far. So I'm familiar both with it in legal terms and its more common political terms these days. So yes, I'm familiar with disparate impact. I really don't think Democrats will win. Civil war might happen on them winning. I don't know, man. Are you looking at the polls? The polls are pretty horrible, and people are voting. It is with some regret that I am forced to forecast a Biden win. It's not because I want to, really, but Trump's debate performance was horrible. It was technically horrible, and there were opportunities Trump had to change the game, and what Trump did was off-putting, and there were technical flaws, there were procedural flaws, there were strategic flaws, and there were opportunities that he had in his answers that he didn't take, and he didn't let Biden talk. I think Trump made huge mistakes in the debate, and I don't see how he comes back from that. People are already voting. The last time I checked 538, it was projecting Biden to win with like 85% of the vote. And the thing that ultimately changed in the 2016 election, because at one point on 538, Clinton had a 85% chance of winning. On the day of the election, it was like Trump had a 23% chance of winning, something like that. So there was a 10% shift, something like that, between that and the election. And the thing that changed was the Hillary emails. There were two things that happened. First, the Access Hollywood tape came out. The grab him by the P word, right? That tape came out. And Trump went into hiding for like 3 weeks before the election. So that forced the conversation to be about Hillary, because people weren't talking about Trump anymore because Trump wasn't in the news. If you go back, look back what he did in those 3 weeks before the election, Trump was not there to be found. He went off the scenes. And because Trump there wasn't to suck up all the oxygen, people started talking about Hillary and her weaknesses. And the other thing that happened is that the Comey came out with a report from the FBI saying there were all those problems with the letters and the emails and the servers and stuff. And in the absence of talking about Trump, and the only thing to talk about was Hillary, people started talking about that. And that was a 10-point swing. And that was enough for him to win the election. You know, there's nothing like that that's going to happen this time. There's no thing that's going to drop that is going to create that situation. So it's just not there. It's not there to be had. And so, yeah, Trump is going to lose. I'm pretty sad about it, but that's where we are. And then Biden will take over, and he'll be president for 2 years and a day, and then he'll turn it over to Kamala, who will then run for 2 terms and be president for 10 years. Hooray! Hooray! It's a problem. Could an amendment stop court packing? Yes, an amendment can always stop court packing. Of course, an amendment can do anything. So saying, any answer I give to any legal question doesn't suppose the existence of an amendment, because an amendment is a God button. So yeah, an amendment can do basically anything. So sure, yeah, an amendment can stop court packing. Yeah, congratulations. So yeah. Trump has one unfocused error, another after since the debate. Yeah, the debate was also a massive unfocused error. I already gave my answer in a previous stream to the white supremacy question. I already gave it in a prior stream. You can go look it up. I think I made a video specifically about it, about Trump making the error. There was a great answer for him to be had. It was a really easy answer, and he could have answered the question and also turned it on the left, and he blew it. He blew the white supremacy question. And a lot of people were like, well, he's answered white supremacy a whole bunch of other times. So freaking what? It was an outstanding opportunity to answer it again clearly, even if he said it 500 times. Who freaking cares? Answer it for the 501st time. Jesus Christ. It's a time for you to answer the question, answer it directly, and also destroy the left in your answer. I've already given my answer off the top of my head, which is way better than anything Trump had. It was an easy give me. He blew it. And the other thing he did is not allowing Biden to talk, which was really irritating. So yeah. You hope you're wrong? The polls are being manipulated to encourage bandwagoning? I don't know, man. I don't know if there's that many hidden Trump supporters out there. That's the late great hope, is that there's a lot of people who are really reluctant to express their hope to pollsters. But man, you have to hope for a lot, man. You have to hope for a lot to get there. So I might be wrong, but no. Okay, that's just no, yeah. I don't think that's flying. I think Biden's going to win. Probably appoint Cuomo as Attorney General. That'll be good. And then all he has to do is make it 2 years in a day, man. All he has to do is make it 2 years in a day. January 21st, 2023. Kamala goes up to Biden and says, "Hey, sign this paper." In response to the dictionary, oh my God, there's hard copy dictionaries with the wrong points. They must be destroyed. Yeah. If Trump winds up winning after all this, that'll be nice, but no. He'll take all our guns. That's distinctly a possibility too. Yes, you are correct, sir. Cuomo is a piece of S. I agree. Not my cup of tea. Yeah. I'll stick to my printed dictionary. That's fine. If Biden wins, at least it'll get a lot more content on the channel 5 of the Flynn case. Yeah, that's the ultimate kick me in the teeth. That's the ultimate kick me on the teeth. If Biden wins, the Flynn case, which I said will never die, because unless Trump pardons him on his way out, which is always possible, but unless Trump pardons Flynn on his way out, he appoints Cuomo as Attorney General. Cuomo appoints U.S. attorneys who suddenly withdraw the motion to dismiss, and we're all into a whole nother world of legal pain. So at that point, the Flynn case will indeed never die. Yeah, that's definitely what I want for my channel, man. Just more and more Flynn content. Biden winning isn't all bad. I get to talk about Flynn more. Redefinition of words to align with newspeak is carried out to the extreme. Yeah, that's fair enough. Yeah, certainly. Do you think federal laws cracking down on cyberbullying or doxing are on their way anytime soon? Yes, probably. I think so. And it'll be interesting to see what they come up with, I guess. There might be proposals that are legal. We'll see what the Democrats come up with. And when they pack the court, I guess they'll be legal after all. Yeah. She apologized for using it. She's spineless. I disagree. In that scenario, I think the apology was well warranted. I think apologizing to the left in general is a mistake, but in this context, I will disagree with you. I think it was a prudent move. I think she did the right thing in that scenario. Mary Moster's just another fascist to the left, yeah. Yeah, it could be worse. It could be just all Vic Mignogna all the time. Personally, I kind of prefer Vic Mignogna all the time at this point, yeah. Lo, your audio was out half the way through. I'm well aware, thank you. Maybe they took a bribe or something to take it down, yes. Dictionaries are getting woke, yes, they are. Winston's Neighbors was working on the dictionary. Very, very cute. Very nice 1984 reference. I'm going to argue from a logical semantic perspective. The whole point about the term preferences being offensive implies there's a choice, but that would imply only to an absolute idiot. Fair. You realize that the N-word was in the dictionary not considered offensive at one time. I do. Dictionaries display common definitions as used. Correct. When they get changed, when someone brings up a new usage or how old usage has changed. True. The offense of the word has nothing to do with how it's defined in dictionary. That's true. It depends on its usage. I agree. You're apparently and completely in the effing dark about transgender and LGBT issues. I'm not. I'm not in the dark about LGBT issues. My objection is not necessarily with the definition and it being changed. My objection is with the timing and the procedures that was used in that change. I'm not focused on the result. I'm focused on the process. And the fact that Merriam-Webster abrogated its normal process to publish this definition, even if they were planning to do it at some point in the future, the fact they abrogated their normal process for what are clearly, in my mind, political reasons, is, in my opinion, a difference that matters. So yeah, even assuming this is where the dictionary was going to go in 3 months, it wasn't today. And the fact they did it today, I think, is in of itself a notable thing. And if you disagree with that, if you don't think the process matters, then we just disagree. I think the process is relevant. The fact they abrogated their process for what seems to be clearly political reasons is, in my opinion, the problem. Even if the result is not a problem, the process was corrupted. Logic allows for P words. Being seen traces of P words acceptance on the left. Maybe. You and Barnes, you two can wrestle over the wisdom of the ACB. I'm sure we will. Sexual preference has been offensive to some groups for long times. I'm aware there's been articles written about that in the past because it infers sexual orientation is simply a preference from being straight. Fair. It depends on where you are geographically speaking, what their experiences is. This isn't new, but outside the LGBT communities are not generally savvy. I'm aware of articles written a couple of years ago on exactly this point. I saw a Slate article written from a couple of years on exactly this point. So, yeah. Dictionaries change definitions based on common usage. Just a quick question. When in the constriction does it give the right for non-same sex? Where in the constriction? Constitution. Where in the Constitution does it give the right for non-same sex couples to marry? If there isn't a right expressly given in the Constitution, should all laws pertaining to marriage have been struck down as constitutional? You know that it isn't in the Constitution. The right to marry someone if you're choosing. If not, who gets to say who you can marry under what terms? Will it be treated as someone else's life and nothing to do with you? Then you get to say who you'd marry. It seems a single... Okay, so with respect to gay marriage, of the constitutionality of gay marriage, I don't like Kennedy's opinion in Obergefell. It's too floaty for my taste. I don't think it was well reasoned. I think there was a better way to write the idea than what Kennedy came up with. And so here is my view on the constitutionality of gay marriage. All right. So you have to accept a couple premises. Premise number one is that there is a right to marry if you're straight. Okay, so there's a right to marry if you're straight, which, again, incidentally, some people don't actually agree with. Some people do not believe marriage should be a government institution at all. So some people think that marriage should not be government and should just be done at churches or civically or whatever. They don't think it should be government-based. And that's a wholly valid opinion if you don't think straight marriage should be a thing recognized by the state. So premise number one is you have to accept that straight marriage is recognized by the state. Premise number two you have to accept is that animus alone is not a valid reason to pass a statute. Merely because you dislike something is not enough reason to pass a law against something. Particularly when it comes to people, that animus alone is not enough. And that is, incidentally, the state of the law right now, is that animus alone is not enough. And that well precedes Obergefell. Is the state of the law. That animus alone, hatred alone is not enough. And one of the reasons for that, incidentally, if you want to put that in constitutional law analysis, is the bare minimum rationale the government must pass to do anything is rational basis. It has to be rational. And the opposite of rational is what's called arbitrary and capricious. Arbitrary, capricious is the opposite of rational. And so the idea is that pure animus alone is arbitrary. It's capricious, right? It's not based on any reasoned. It's not reasonable. It's not reasonable because it's not reasoned. Pure animus alone is not reasoned. So it's not reasonable. So you can't pass rational basis because it's not rational. It's not reasoned, right? So pure animus isn't alone because you can't pass rational basis because it's not reasoned. All right. So those are the two premises you have to accept. You have a right to straight marry, and you can't do something with the government with pure animus. You need at least rational basis. All right. All right. So once you accept those two premises, you come to gay marriage. And then, for me, looking at this legally, and incidentally, this was a late developed opinion. I didn't think this earlier in my life. This was an opinion that I developed as Obergefell was being argued and being decided, right? So as Obergefell was being argued, this is where my opinion on this changed, because I had to actually confront this in a rational way. All right. So I didn't always think this. I came up with this as I was listening to the oral arguments and the briefing in Obergefell. Somewhere in that period is where I came up with it. And what I said is, you can't pass rational basis review. You can't pass rational basis review for discriminating on gay marriage. You can't do it. You can't come up with a reason, because every reason doesn't work. That's my analysis, right? Every reason you can come up with doesn't work. None of them pass analysis. They don't hold up. They don't hold up. And so because you can't come up with a reason that works, you can't do it. And so I'll give you an example of some of the reasons that you could try and say, here's the reasons we're going to do it, and see if they work. Well, so one of the reasons you might try is, well, we want to promote having kids. We want people to have kids, and marriage is a way to encourage people to have kids in a way that ensures that they'll be raised by two able-bodied people. It's like, okay, we want to promote marriage because we want to encourage people to have kids in marriages, and that will ensure stability because there will be two people, two incomes perhaps, two loving people, and that will be positive. We want people to have kids in a stable relationship. Okay, but that reason doesn't work. Why? Well, you go look at the arguments of Obergefell. You go look at the arguments. You go look at the oral arguments. Are you making any effort at all to ensure that this married couple wants to have kids, that they can have kids? Are you even asking? Are you even asking on the forum, do you plan on having kids? Are you attempting to prevent two 80-year-olds from getting married? Are you even asking? And the answer is no, you're not. Right? You're not. So having kids is not enough because you're making no attempt to base marriage on that. You're allowing people to get married who announce they have no intention of having kids ever. You're letting people get married who have no ability to have kids ever. So the reason doesn't work. Right? And the same problem with like other examples. Like every rationale that you apply or try to apply doesn't work. You can't apply it universally because it's not consistent with your behavior. So your reasons are therefore pretext, right? Because you're making no attempt at all to limit marriage based on what you say your reason is. Well, the reason we want straight marriages and not gay marriages is because of this. But you're making no attempt to restrict marriages to actually promote that, or trying to in any way forbid marriages that won't accomplish that. So your reasons are all pretext, right? And therefore you can't meet rational basis. And if you can't meet rational basis, it's arbitrary. And if it's arbitrary, you can't do it if you're a government. So that's my analysis from Obergefell. That's where I come out. You can't do it. You can't find any reason that works when you actually look at how states actually do marriage and what they really actually do. No reason that you say is actually consistent. You make actually no attempt to make sure marriages conform to that reason. It's all pretext, and so it doesn't work. Yeah, so it doesn't work. So, yeah. So that's my analysis from Obergefell from a constitutional perspective. Because you can't make even rational basis, and that's the bare minimum. If you can't do it, you can't go there. So that's where it's going. For me, gay marriage falls under equal protection. Yeah, exactly. You need bare minimum rational basis, and you can't get there. Obergefell majority opinion is just a historical timeline. I just think it's weakly written. It's written too much in poetry. It's written too much in feelings, basically. It's not really rooted in. It's just a weak legal opinion, in my view. I don't think Kennedy's opinion was very well written. It's inspiring, but I just don't think it has the legal heft. So I just didn't think it was well written. Government should be involved with marriage. It's a social religious institution. Yeah, that's a valid perspective. And if you accept that, then my logic fails. As long as you're doing it consistently. You could say no marriage for anybody. That would be fine. I don't think it's necessary for the state to recognize the right for it to exist. I'm not even sure what that exactly means. The state has to. I'm not sure what it means for the state to recognize a right. Something can exist without the state recognizing it. I'm not even exactly sure even what that means, but okay. Does gay marriage restrictions pass Jacobson? No, Matt. Thank you for playing. The LGBT community distinguished itself. Yeah, you could say, someone said, you could say that allowing straight marriages promotes having kids more so than disallowing it. Yeah, but the problem with that is you're making no attempt to restrict marriages to people who want to have kids or can have kids. If your rationale for allowing marriages is it would encourage people to have kids because they're going to sleep with each other and they'll have kids and they'll do so in a stable environment, but you're making no attempt at all. You're not even asking a question on a yes/no box. No state is putting a yes/no box of do you intend to have kids and then denying marriages to people who say no. No one's attempting to do that, and I'm trying to ensure that perspective so it doesn't work. It can't be your reason. It can't be your reason if you're making no attempt to do that on that reason. It doesn't make sense. Sterile people can marry. Exactly right. Right? You're making no attempt. Someone said, what about religious reasons? You can't do it. You can't do religious reasons because you can't. First Amendment, man. You can't do religious reasons because First Amendment. Congress shall make no law respecting religion or establishing religion. Religious reasons for the government are invalid. You can't base it on a religious reason. Congress shall make no law. Religious reasons are not valid under the First Amendment unless you can pass strict scrutiny. So if you can pass strict scrutiny, then sure, you can discriminate on the basis of marriage, on the basis of gay or not gay. If you can pass strict scrutiny, then sure, you can do it because then you can meet the test under the First Amendment under strict scrutiny because you're discriminating on the basis of religion now, if religion is your basis. So sure, if you can pass strict scrutiny, but you're going to have a bit of a time passing strict scrutiny when you can't pass rational basis. That's going to be a bit hard. So you can't do that. Now, religious reasons are not going to fly. The difference is that no two good people could have, under no circumstances, have kids. Yeah, not biological kids, that's sure, but you're making no attempt on the other side making no attempt to restrict it on that motive. So no gay person could have kids, but kids aren't your reason. And the reason I know it's not your reason is because you're making no attempt to conform marriage to the reason. If the reason is because people will have kids, you have to make some attempt, any attempt at all, to conform marriages to the reason. Right? This is like basically the because of language from Gorsuch's, to go back to Title VII on the discrimination on sex. It has to be a reason at some point, at least one. It has to be based on that. And it can't be based on that if you're making absolutely no attempt whatsoever, even cursory, to try to limit marriage to people who are capable of or want to have kids. You're not even making an attempt. You are allowing people to marry who you know for an absolute fact cannot have kids. So how can it possibly be, well, we're allowing marriages based on the fact that they might have kids? No, you're not. You're clearly not. You're making no attempt to do that. That can't possibly be your reason. It's belied by your actions. Your stated reason is belied by your actions. They are not conforming. They're not even close to conforming. It's not like they're not perfect. You're making absolutely no attempt to conform them. So it can't be your reason. So no, it doesn't fly. Can I sue Facebook when they censor a DM for wiretapping? Probably not, because the terms of service probably allow Facebook to do it. I don't care who gets married because who gets married. I care about discrimination unless the government gives you tax breaks. Yeah. Man edited screwing that up. I'm effing libertarian in the end. Do what you want, less regulation in the end. Okay, fair enough. What do I think about sperm donors being forced to pay child support to the women that use them? Not familiar with that. I'm not familiar with the operative state issues on that. So, yeah. What about common law tradition back to England? What about it? What about it? I mean, come up with a reason at any point ever. And I don't know if like at common law or England what they did, but like it doesn't make sense. It doesn't make sense. So it doesn't work. If you're strict marriage so people can have kids, then you can potentially stop gay marriage. Yeah. If your real reason is we want to have kids, then trying to restrict marriage to that basis at all in any way would be great. Yeah. If marriage is a contract, you can't sign a contract, you can't get married. That's essentially true as a general proposition. My knowledge of law is lacking. That's why I'm here. No problem. That's why I'm here to help. Yeah. Modern marriage is an absolute disaster. Perhaps it is. But, disaster or not, people are entitled to the equal protection of the disaster. So, the problem is that you can't come up with a rational basis. All the rational bases fall away. None of them work. None of them stand scrutiny. And you can't get to rational basis. You can't do it. So, yeah, that's where I come out on Obergefell. I think Kennedy's decision was very poorly written. I think it was mushy and washy and ethereal and very poor. So I very much disliked Kennedy's opinion in that case. But the conclusion, couldn't disagree with it. Couldn't make it work. So that's where I came up with it. And if you find a rational basis, let me know. But remember, you have to actually show that some state somewhere is trying to restrict marriages in any way at all to that reason, that they actually are trying to accomplish that basis. And it's not just a pretext. You have to show that they're actually trying to, in some respect, basis marriages on that. And then at least maybe you could get to rational basis, but none of them work. So that's where I sit on Obergefell. So yeah. And I wasn't there. I wasn't there initially. I wasn't there for a long time. And then when Obergefell came along and I started reading the briefs and I actually started trying to apply it, when I was actually forced to confront the issue. So maybe that makes me a really good judge, right? Because my initial bias going into and analyzing this case, maybe it's what makes me a good judge. My initial bias going into the case is, gay marriage doesn't make sense. I would have ruled the other way. But then as I actually started reading the briefs and actually started listening to the arguments and actually started thinking about it, I couldn't make it work. I couldn't do it. And then, so therefore I'd have to go the other way. So maybe that makes me a really good judge, because it wasn't based on what I wanted. It was based on what the law required. I couldn't make it work legally. Couldn't do it. Anyways, so that's where I, came out legally. So anyways, I'm going to sign off. We've been here for 2 hours and a half. We've had a good time. We've had a lot of fun. I hope you've had a lot of fun. And thank you for all the members who were there and enjoyed this. I hope the rest of you enjoyed it as well. If you've enjoyed this stream, please give it a like. If you're not already a member, you can become a member by hitting the join button. If you're not subscribed, please subscribe. And until later, my friends, I hope all is well, and cheers, and goodbye.